ways to opine on whether or not they have any issue with the settlement itself.
Right, and two quick things from a defense perspective there. You know, removing for CAFA, you know, you're implicitly stating that the case is worth more than $5 million, explicitly stating as well. So there's definitely an internal weighing of cost benefit that you want to go over with your client in order to really determine whether or not you want to put out there that this is a $5 million case. In terms of the settlement considerations, you know, the notice to regulators, or the regulatory boards, that's a lot of work, and a lot of letters need to be written. You don't have much time to do it. And say you have a case like, you know, a securities fraud case or something where you know that you have people all over the country, but you're not entirely sure of where they are. You need to send notice to every state. Every state needs to have notice unless you can determine exactly what states are impacted. And that's just a little kink that you need to be aware of.
So we've kind of given you an overview of what is necessary to be able to certify a class. We've gone through the elements. And so you might be thinking, okay, I understand that, but what is a potential class case? The really neat thing about class actions is that it is not confined to one particular area of the law. I mean, these cases are in a variety of different contexts. Like Jim said, they could be securities cases. Jim and I, we deal in the context of collections cases. You have a client that has been sued in Associate Circuit Court. There may be a class case in that. I mean, most of the class cases that I do right now deal with Associate Circuit Court cases where there's a pattern of misconduct or not, some procedural error, things like that, or miscalculation of interest, principal, whatever it might be. Collection cases can be a very good area for class cases, and that's because in these types of cases, they tend to be high volume. Its conduct is going to be the same, and we'll talk about that in a second. So collection cases, does your client own a cell phone? The answer is probably yes. And if the answer is yes, your client and you have probably been getting at some point in time unsolicited robocalls or telemarketing calls. Those are potential cases. Does your client have a debt collection issue? Are they getting collection letters in the mail? Could be a potential case depending on the letter. Traffic tickets, there's been settlements in the St. Louis area dealing with traffic ticket fines. Repossessions, does your client have a repossessed vehicle? There's been class actions over the proper notices for repossession. Sales tax, did your client maybe pay an inflated amount of sales tax? Potential case there too. And then improper billing practice, improper fees, things like this. The big picture is this: potential class cases are abundant. You just have to kind of understand what makes for a good class case. And we'll talk about that in the next slide. So what makes good for a good class case is really a form, conduct, or practice. That's really good. So in the collection cases, again, if, for example, there's a miscalculation of interest and you figured it out for your client's case and it's a particular creditor, the chances are that's the same process that is being used to calculate your client's interest as potential class. So that could be a case. Form contracts are gates. So if your case is based on some violation of a form contract, maybe there's an improper fee. There's been a lot of unauthorized practice of law and doc fee and admin fee cases brought under form contract cases. Those can be great cases. Uniform charges, the same thing. But remember, again, varying damages is not a basis for a court to not certify a class. Just think of form practice, form conduct. And that's kind of the starting point that will help you determine whether or not it's a potential case that's worth pursuing. And Jim's going to talk from a defense side, what are some potentially problematic cases that you want to avoid?
Right. And so the first personal injury cases, which we generally alluded to previously, but you know, you have huge issues with different damages, different latency periods, the amount of damage, the types of injuries that don't necessarily equate to really putting out a good class case. Toxic tort cases, different products, manufacturers, times, exposure levels, different damages. You know, a lot of times MDLs are better situated for these types of cases, mass tort litigation. As I'm sure most of you are aware, all of the asbestos litigation that goes on in Madison County and St. Clair County and St. Louis City as well, to get things on a nationwide basis kind of centralized. Oral representation and scienter. These are requisite speaker intent cases. A lot of times you'll see, especially in scienter, securities cases, shareholder corporate fraud cases, pump and dump schemes on stocks, that type of stuff. The big issues here are really whether you can prove a non-fraudulent intent, and then whether or not the individuals that heard it truly relied on the oral representations that were made. Yeah. And you're dealing with hundreds of people or thousands of people, especially on these securities cases. It's kind of difficult to prove. And you kind of get into an individual basis type analysis where you could try to get a class thrown out. Cases that require the application of laws in different states. In Missouri, we're seeing a lot of MMPA class action cases, and you really can't do a nationwide class on someone that was injured, in Wyoming or whatever on a Missouri MMPA case. And so not only are you're essentially limiting your class size, and unless you can bring it under some other form or possibly a federal statute like the FDCPA or something like that, you're going to be creating multiple classes in your case. Cases that defy common sense. This is the fun one. I feel like these are the cases that kind of give class action litigation a bad name. These are the cases you hear about on the news or you see on, popping up on CNN. Cases like, Starbucks was putting too much ice in my coffee, or Subway foot-long sandwiches are actually 11.8 inches and not 12. These tend to be better for publicity. And, you hear about these cases when they're filed, when they're first getting going, and people are talking about them. But what you don't end up reading about is the fact that the case ends up getting tossed. And so, I feel like the general population kind of believes that, that's really what class action is all about, when in reality, there's some very good class action cases, and there's some very pertinent ones in terms of, successfully moving around this litigation.
And it's really important. I mean, you can the fun thing about being class action lawyers, you can obviously be creative and intellectually challenging and stimulating, but you always have to have that common sense. Like, don't get too cute, because a judge is not going to like that, and it could make your future cases look bad too. And so now that you know kind of what the elements of class certification are and what some good cases and bad cases are, let's kind of move over to mediation. And this is really fun. And this is why. It's because mediation of class cases are so much different. There's so much more room for creativity than a typical case. And so let's say you have a personal injury case and you mediate it. Usually the big thing that you're negotiating is the amount that's going to be paid. There may be some other terms, confidentiality or indemnification or whatever, that are negotiated, but the big thing is the money. And the big thing obviously is always the money in every case. But in class actions, there are a ton of moving parts. And so what do you do to set yourself up for success if you have a mediation, but you have all these moving parts, unlike a traditional case? So the first thing you should do is you should create a settlement term sheet. I'm going to show you a settlement term sheet in a second. Hopefully you have a Word version of that. We've supplied that with the materials. And that's just a form. Like, you can tweak that any way you want or add things, but it just gives you kind of a baseline of how this works. So here's why it's really helpful. So obviously we're going to know that we have to talk about the amount of the relief, but we also it's really important, the scope of the release. A scope of the release is going to be different in a class case as opposed to a scope of a release in a personal injury case. The amount of the representative service award, how much is the class representative going to be receiving for their service in this case? The form of relief, is it cash? Is it coupon? I never do coupon settlement, but we'll talk about that. Is it injunctive relief? The type of settlement, is it claims made or is it just opt-out settlement? How do you notify the class? You've got to go through go through basically, are we going to be mailing them things? Are we going to be emailing them things? Are we going to be doing notice by publication in a newspaper? Are we going to be doing a social media campaign? What do you do with the remaining funds? So let's say you have a settlement fund of $1 million and a lot of people don't cash their checks. What do you do with that? Reversion, does any of the money go back to the defendant? How do you deal with objectors? There's a lot. And you're probably thinking, how in the world can I get through all this in a mediation? It's hard enough for me to get through this in a personal injury mediation. This is why providing a settlement term sheet to your opposing counsel a couple weeks in advance of the mediation is really helpful. So let me show you a settlement term sheet very quickly.
Right, and while Chris is looking for that, I'll just go into briefly, from the defense side, these types of settlement term sheets are of huge impact and importance when you're trying to prepare a client or an insurer for a mediation like this. Insurers, which are involved in many of these cases, aren't always litigating class action cases. And so there's also teaching on the defense side that goes into making sure that your client and the insurer know all of these moving parts, that you're teaching them about all these moving parts, that they're understanding what's going to have to go into this settlement. It's not just like on a PI case, the demand's 100 grand and insurer gives you 30 grand in authority going into the mediation or something like that. There are 7, 8, 9, 10 different topics that you need to discuss with your clients or your client ahead of time, and try to get the ball rolling on exactly how we're going to combat this, get the client up to speed on the fact that this isn't going to be we settle the case here, this is the term sheet, or a preliminary term sheet, you cut a check and 3 weeks later the case is dismissed. These are really good ways to kind of not only work towards a mediation, but a teaching tool that a defense attorney can use as well.
And Jim, can you see the settlement term sheet on your screen?
Yeah.
All right. So this is a sample settlement term sheet. And so the first thing is you want the settlement class definition. And so that might be the same definition that's in your petition or your complaint, or it may be some modified definition that the parties agree to. And the other thing I would tell you about a settlement term sheet is this. This is another reason it's really helpful. Not only does it kind of give you an idea of what to expect going into the mediation and allows people to prepare and whatnot, but a lot of times in just a traditional mediation, this mediation starts off terribly. The plaintiff makes a really high demand, and then the defendant comes back and makes some really lowball settlement offer, and everyone's upset. And it kind of stalls things and you build no momentum. One of the benefits of the settlement term sheet is a lot of times when you start getting into this and you start talking through it with the mediator, you can build positive momentum because there are some things on the settlement term sheet that you're going to be able to agree on. And so you can use that positive energy to kind of move the case forward and have a better chance of settling the case. And so you've got here the settlement class definition, and then you've got here number 2, settlement class member rewards. This one says each settlement class member who basically doesn't opt out or object gets this relief. And so you want to describe what that relief is. Let's say it's payment. Is it going to be check? A lot of settlement administrators now, because of the way technology is moving, can do Venmo. Are there other forms of payment that are you going to do like a credit to somebody's account? And then the other thing too is if it's a check payment, what do you do with the uncashed checks? A lot of times what we do with the uncashed checks, because you don't want just a fund sitting there with some amounts in it forever, is if the checks are not cashed within a certain period of time, those funds usually go to some organization. This is called Cypre recipient that serves a similar interest that your case was supposed to serve. So if I do a consumer case, a lot of times the Cypre recipient is Legal Services of Eastern Missouri. And the purpose, as you can see there, is you have to put the purpose. It would be for consumer education, for example. That's really important because you need to know exactly where every dollar of settlement's going. Objections are really important. We'll talk about that too. Total settlement amount, class representative service award, attorney's fees and costs, class notice. And so for class notice, it talks about selecting a settlement administrator. Who's going to pay the cost of that? It's usually the defendant. What data needs to be provided? What's the form of notice? How's the notice going to be sent? And then deadlines for getting preliminary approval, which is the first step for approval, and final approval. Now, the class settlement is unlike a traditional case for a number of reasons. And one of those reasons is that the court actually has to approve the settlement. Now, there's a question about, do class action mediations take longer than other mediations? Sometimes they can, and sometimes they can resolve in the same period of time. I've had cases that we've needed multiple mediation sessions. That's common. That's not abnormal, and sometimes you have to do that. But
Right.
what we're telling you is that if you position yourself for success, and you start with the settlement term sheet, so a couple weeks in advance, maybe even a month in advance, so you can open this dialogue, that really helps things, and it really helps make your time at mediation much more well spent and much more efficient.
Yeah, and to chime in there, Chris, our mediations, we've got them all done in one day. They've been a lot of 8 to 8 days. But a lot of that is because we've been talking about mediation for weeks in advance, and we come in with our clients properly up to speed on what they can expect, and we've already started doing some negotiating ahead of time. And so, while yes, that is a potentiality that it could be multiple days, the preparation of counsel ahead of time can really cut down on that time in mediation, which is beneficial for everybody.
And the most important thing you have to ask both sides, not just the plaintiff, not the defendant, is the court going to approve this settlement? Is it fair to the class members? Is it giving them good relief? That is the most important consideration. You, plaintiff's lawyer and plaintiff, and the defendant can sign a settlement agreement, but honestly, it doesn't really matter to a certain extent, because it's the role of the court, not the counsel, to approve the settlement. So if the court does not approve that settlement, all your work is by the wayside. And so that's a really important thing that you have to keep in mind with these settlements. You want to talk about the objection, Jim?
Yeah. Why don't you go?
Yeah, so the other important to ask is the settlement likely to draw an objection? So class members have a variety of rights. They have a right to opt out of the settlement if they want. They have a right to get counsel if they want. They have a right to object to the settlement if you want. And so objections can do a couple of things. They can result in a settlement not being approved. I mean, the court more often than not overrules the objections, but they can do that. But more commonly, what objections can do, and I've had this in a case, is they can result in a case actually being delayed for a year or more on appeal. So there is, unfortunately, there's this concept, I don't know if you've heard of it, but it's called green mail. And this is kind of a common practice, unfortunately, in class action procedure. And the way this works is some lawyer finds, he sees there's a big settlement, and he goes out and he finds somebody that is a class member in that case, and the lawyer lodges an objection to this settlement for whatever reason it is. And this is what they do a lot of times, not always, but this is pretty common. They will say, hey, we've got this objection to your settlement. You're asking for too much in attorney's fees, or the relief is inadequate, whatever. If you pay my client $100,000 or $200,000, we'll go away. And we call that green mail. Okay. And sometimes people will pay that, both sides, because they just want to be done with the case. They don't want to deal with the objector. So we had a case where that came up, and we did something very, very helpful. And if you look back at the settlement term sheet, there's a provision in there that talks about how do we deal with objectors? What do we do in terms of discovery for objectors? And so what we did in that case is we actually put a provision in the settlement agreement that was approved by the court that said, if there is an objector, we have the right to take expedited discovery from that objector, including their deposition. So what we did is we got an objection, and it was a professional objector, the lawyer that did this. We got the objection, and we invoked that right, and we took the person's deposition. And the person had submitted this objection that was attested to under oath and whatnot. And we asked her questions about the objection, and she had no idea what the case was about. She was complaining about the relief provided to the class. She had no idea what the relief was. She was complaining about the attorney's fees. She had no idea what the attorney's fees requested were being, and she had no idea what the case law was in terms of a reasonable fee. And even though it was ridiculous, and the district court in that case overruled the objection, guess what? They appealed it, and they, with the hopes that we were going to pay them off, and we didn't. So we went through the appeal, we won the appeal, but it tied up the case for like a year and a half. And so you've got to make sure, and this is one of the benefits too of having a case settled in state court, is that in federal court, sometimes you're more likely to get these objectors because everyone can see the case on Pacer. And so a lot of these professional objectors were kind of troll Pacer and find cases, lodge objections, and tie up your case. So that's another thing to keep in mind in terms of settling a case. Even if you're in federal court, there are sometimes creative ways that you can get the case back down to state court and settle it there to avoid that issue.
Right. And so a big issue here, and this is a lot in dealing with not only your class admin, but something you can figure out ahead of time, is how are these settlement payments going to be structured? Direct payments, direct payments are essentially what they sound like, direct payments. Each person in the class will get X number of dollars. There are what we talked about, the fact that damages don't always have to be the same. The direct payments don't have to be equal to everyone. It could be written into a settlement agreement that they're going to be based on a pro rata share of the overall damage pool. Or in terms of, like a debt collection case, you can even write it in where, we'll have a spreadsheet with the amounts collected, say, from each individual, and they would get that much in return, or a percentage of that much in return. So there are ways to, which takes more time and more energy, but there are ways to figure out direct payments with different damages. Claims made, this is going back to the cypre kind of area, where notice will be sent out to potential class members, or at this point class members, that state that they will only opt into the class by filing a claim form. They can opt out of the class if they don't want to sign the form, but they will take potentially a pro rata share then of the pot that is attributed to the class, or they will get their agreed to amount if they make the claim, and then the rest of that pool will go to cypre. Chris, I don't know if you want to touch on coupon. You said that you never do coupons, and I'd kind of like to hear why.
Yeah, so there's some lawyers that will do coupon settlements, and remember, you should know that actually coupon is a defined term in the Class Action Fairness Act, and coupon is a different being than a gift card. Okay, a gift card, you can just use a dollar for dollar transaction. A coupon, you actually have to make some type of a purchase to get the benefit of the coupon. So as a consumer advocate, I never do coupons, and here's why. It's because I have just sued a defendant saying they have violated a consumer protection statute. So to me, it's completely counterintuitive and improper to then say, okay, well, here's a coupon to go continue soliciting business at the defendant you just sued for violating, maybe the Missouri Merchandising Practices Act. So that's why I avoid that. And plus, if you're in federal court and you have a coupon settlement, it's going to raise eyebrows, and then CAPA can potentially be used to restrict the attorney's fees you recover on that case. One thing I'll say about claims made is this: claims made is a huge item of negotiation and discussion and mediation. Defendants always want claims made settlements because claims made tend to be 5% or less. It depends on the dollar amount. It could be more than 5% if it's a bigger potential check for the person. It could be less if it's a smaller check. But defendants are always pushing for it. I always avoid claims made settlement because I feel like it doesn't get enough payment many times to the class members. But we're going to talk about this in the very last slide. We've got a couple minutes about creative ways about how you can deal with claims made settlements, because some cases you can't settle unless it's claims made, like the defendant won't move on it, but there's still ways to get appropriate relief for your class. Other considerations for class settlements: funding. What's the timing? Is there a settlement fund? In other words, does the defendant have to put all the money into a fund? Like if you said it's $3 million settlement, do they have to deposit $3 million into the fund? Or do we just have to see how many claims are made and then we pay out that way? So those are things to consider. And Jim, do you have any thoughts on that one?
On that one, I mean, that's pretty self-explanatory. I would say going back to the claims made on the defense side, claims made with reversion is pretty much option A for us. But like Chris said, it's usually going to be met with um, quite a bit of pushback. And I want to touch on the equitable relief, but that may be better discussed after admin stuff. But
Yeah.
just, you know, especially in terms of seeking approval on these classes, you know, you need a proper percentage of damages to go along with attorney's fees. They can't be too much, and you're trying to create a pool or a damage pool that is equally divided, and not one area is too much. You know, attorney's fees aren't 60% of the pool or something like that. And a lot of times, equitable relief can be given on the defense side, where, you know, whether it's a waiver of something or some sort of other agreement where you're not explicitly needing to exchange money, but at the same time, there is value to that relief that you're giving. And if you can put a dollar price on that value, or come to an agreement with opposing counsel on the value of that equitable relief, you can write that into your preliminary approval and use it to give something of benefit to the class, and still have your, you know, requisite attorney's fees, and still have your damage pot, but not have to give that money out of hand necessarily.
And so the other recipe for success is not only a term sheet, but it's settlement administration. And so you should have a settlement administrator available. There are companies, there's a lot of companies out there that do professional settlement administration for class actions. That's all they do. You want to have them available. You want to talk to them before the mediation. You want to have them available by phone because they can help with a lot of things. So as from the defense perspective, the defendant usually has not been sued in a class action before, unless it's Jim's client. And so they usually don't understand when you hear claims rate, they think, oh my gosh, everyone's going to make a claim. We're going to have to pay out all this money. And so for defendants that have that kind of an expectation, the settlement administrator can be really helpful because they can say, hey, look, this is what the claims rate is. Also, they are really, really helpful in terms of notice. That's the biggest thing they do, is send class notice, so the class is notified of the settlement. There's different types of notice programs. There's direct notice mailing, like if you've got addresses or emails, email notice. However, maybe you have a class action and it's somebody sold a food product and it was improperly labeled. Well, you're not going to have people's names and addresses. So how do you go about doing class notice? Settlement administrator can help you with that. They can tell you about social media campaigns. They can tell you about maybe TV campaigns, maybe about publication in newspapers, depending on where the product's sold. So they can really help with that. And more importantly, because the defendant's going to be paying the cost of this, they're going to be able to say, look, this is what the estimated cost is going to be based on the number of class members or potential class members. And so that really helps too, because then the defendant knows, okay, this is the dollar amount that we're looking at. And again, it can be helpful to have that discussion in terms of the types of how you see the case being settled and administered before you get to mediation. And so you focus, when you're at mediation, more on the dollar, right? You can get these other issues aside before you get to the mediation, or early in the mediation, so you build momentum, positive momentum.
Right. And
go ahead.
Oh no, I was just going to say, it's also interesting in that, how important class admin is. Depending on the size of your case or the size of the alleged class action case, it may be infeasible to settle it based off of the amount of work a class administrator will have to do in the case. For instance, like, I had a case recently that ended up settling individually because while there were quite a few class members, the damages were 15 cents a person or something like that. And it was just not feasible. The cost to provide notice and to cut checks and all of that, all of the rigmarole involved with it, the class admin services were going to be a multiple of the damages pool. And so while, in certain cases,
Hello?
can you hear?
Yeah, there you go.
Am I here? Did I break up?
Oh, you're good.
In certain instances, even if a client wants to settle a case on a class action basis, just to get rid of the potential problem, depending on, because 15-cent claim, how many of those are sitting around out there? Well, I mean, just, nip it in the bud, right? But class administrative services are not cheap. And that's one of those issues I feel like, which Chris and I have done a good job with in terms of the term sheet, but there are times, and we've even called class administrate, when we're 95% towards a settlement, we've even called a class administrator, which we've used in the past at mediation, to get a quote there to make sure that, we don't enter into an agreement that ends up just, with some 6-figure class admin fee that is just going to completely throw things sideways. And so, that while it may seem like just a ticky-tack thing or something that's just kind of glommed on at the end, we'll figure this out later. Class administrative services are, especially if you've dealt with this a few times, are very important and something that should not be looked over.
And I mean, in short, really, success at mediation, we've talked about the term sheet. We've talked about seeing if there's terms that can be agreed to before mediation. Big thing especially for Jim and I think it should hold true for everyone, is trust matters.
Yeah.
I always say, it's this old saying, you attract more flies with sugar than vinegar. And so, like, you can be an advocate, but be professional. Build a relationship with your opposing counsel. Work together to see if there's a common solution. And the other thing is this: be open-minded and be creative. Class action settlements are a lot of fun because you have so many avenues that you can take in terms of how to structure the settlement to where there's give and take, where you can reach that resolution instead of just negotiating the pure dollar. And I'll give you an example just to close out. I think Jim and I, in our last mediation, we were stuck on the dollar. Like, the insurance company was involved was not going to pay $1 more. So what did we do? And this is a debt collection context case. What did we do? What we did is we came up with a solution where I said, look, I need more relief for the class. So what we did is we got the defendant in the case to agree to eliminate a significant amount of debt. And so it wasn't anything out of their pocket, but at the same time, it really provided significant relief for the class. So be creative, be open-minded, have a dialogue with your opposing counsel, provide the mediator with the settlement term sheet in advance. These things are going to help increase your likelihood of success at mediation, and you should enjoy mediating these cases. There's an opportunity to be creative. There's a lot of moving parts, and it's a lot of fun. If you guys have any questions at all, don't hesitate to email or call Jim, and I would be happy to talk to you. So thank you so much.
Yeah, and just real, relationship with opposing counsel, I think is very important. Chris, we've mediated a number of these cases to success. We've got a case pending transfer to the Missouri Supreme Court right now. I mean, we fight it out, but at the same time, we never let our professionalism get in the way of working together to try and solve a problem. And I think that's especially true in class action mediation. It really takes both sides coming together to provide that trust and that thinking outside the box and working with someone just in a way that's not typically seen just in your standard mediation. It really does take everyone involved, and it really does take everyone coming together to get a case like this settled. So I'd like to say thank you to everyone as well. And Chris, I don't know if there's any questions or.
No, I think we're done.
Well, fellas, Jim and Chris, thank you. One question I had is, it seems like several cases, class cases that I've had started in state court, were removed to federal court by the defendant. And part of the strategy in reaching resolution is the lawyers were confident that the case by consent would be remanded back to the state court to avoid some of the publicity, maybe streamline the process, because the state court judges may not jump through all the hoops that the federal court might. How often are there cases that start in state court that get removed, and how often do you, as part of your settlement, end up remanding it back to the state court to approve the class settlement?
So when I have a case, I usually file it in state and it gets removed to federal. And the benefit for that is a couple. One is it gives you an easier option to get it remanded to state court instead of filing a dismissal.
Right.
The other thing that helps a lot with that, Rob, is one of the most common defenses that is raised by defendants in these cases is, lack of Article 3 standing. And so one thing that we've done in cases, we can say, hey, we don't agree, but the defendant's got a position, they take the position there's no Article 3 standing. And the reason that's important is if a case is removed to federal court, the remedy is not a dismissal of the case. The remedy is a remand to state court, and so then you can settle the case that way. So,
right. And the cases that Chris and I have been dealing with recently, a lot of times they're federal statutes, but dealing with some form of Missouri civil procedure.
Yep.
And so while I typically like to remove, you would just be going through a big Rooker-Feldman argument and it end up getting sent back anyway, likely. On the non-collection cases, I basically agree with Chris there. And going back to the objections and whatnot, there's are oftentimes agreements made to get a case remanded back to state court for settlement purposes, just to streamline things and, avoid some of the hurdles that you have to go through in federal court.
Great. Chris, Jim, thank you again. And the last slide, you had your contact information, and I know if folks have additional questions, they can certainly reach out to you, and we appreciate you being available as terrific resources to answer those. So again, thank you again, folks. We're going to take just about 9 minutes, and then we'll get started at 2:45 with our next program. Thank you. Is 2:45 to 3:35. So in the next 50 minutes, there's a panel of 4 of us going to chat about arbitration by Zoom. And frankly, the genesis of this idea was based on a case that I was lucky enough to serve as the chair of an arbitration panel. Ryan Carmody, a principal of Carmody McDonald, is with us and was one of the counsel. Paul Henry of Denlow and Henry was the other counsel in that particular case. And Steve Strum, who is a partner at Sandberg Phoenix, also had experience in having an arbitration by Zoom. And it was a different circumstance. I think Steve's was more of a traditional kind of case where there was a pre-dispute agreement to arbitrate and eventually ended up in arbitration by Zoom. But I thought we'd spend just a few minutes, Ryan and Paul, describing, if you would, how did it come about that you had this case in state court in St. Louis County, and how did it end up in arbitration, let alone doing it by Zoom? Ryan, you want to take the lead?
Sure. I talked to Paul about this and he can just chime in a little bit more. But basically what happened was Carmody McDonald represented the University City, and we were condemning out various parcels of land for a Costco development to come right off 170 and Olive. Paul's client, Public Storage, was one of those lucky properties that got condemned. As some may or may not know, the condemnation process can take a while, as you know, you have to get an order of condemnation from the judge. And then if you decide, then you have to have a commissioner's hearing. And if you decide that what the commissioners have awarded, if you don't want that, you do a jury trial on the exceptions for value. And so, Paul, you can kind of give the insight and the background as to how, because it was your client's idea that to actually arbitrate in this situation.
Right. This was a very large commercial property, Public Storage. Many people see it going up and down 170, all the orange doors there in the northeast corner of Olive Boulevard. And there was, and I'm going to reference to Jerry every once in a while, Jerry being Jerry Carmody, who was the other attorney on the case on the other side. Jerry kept intimating that if we got the amount of money that we wanted, all of it, it might kill the project. My client was concerned because the publicity from the project was actually cutting into their business. People were moving out and not renting from them. And so even though we had initially came out of the gate to contest the taking altogether, the jurisdiction of the court, my client decided it was better just to do a take it or leave it type of a thing. We do a binding arbitration, and the city then had the opportunity to say, we'll pay it or we will walk. And so we agreed, we pitched the idea of arbitration. It took a while to figure out how we would end up doing it, but we did come to an agreement. When we decided to do that, when we agreed on arbitration, this is important to note, we weren't agreeing to a Zoom arbitration. This was done probably late summer of last year. If you recall, the COVID numbers were going down. We kind of knew we would be doing a situation where we might be using masks or social distancing, but the pandemic had not turned back into its heated, it had not started to spike again like it did late fall and last winter. And we didn't end up arbitrating this until January of this year. By the time we got to that point, all the parties agreed, including the arbitrators, both parties, that everything would be 100% remote. I think all the witnesses were remote. The arbitrators were in remote locations, and counsel were in their respective offices. So it actually evolved into being 100% Zoom.
And I think, Rob, it was you that said, it's maybe better to do it via Zoom because then I can look at the witnesses' faces and I can assess their credibility rather than having, somebody masked up 6 feet in front or, more than 6 feet in front of you. And so that you, I think, had an experience where you said that was more difficult.
And in fact, about 10 days after your hearing, I heard in a large training room in our building downstairs that can seat about 50, we had a plaintiff who was just dead set on having it live. And, you're talking about mid to late January. So the COVID numbers were high, and I agreed to do it in person so long as we were all masked and all socially distant. So we had a plaintiff's table in one corner and a defense table in another corner. I had a witness table that we had the expert testify from, and I was in the fourth corner. So I was physically probably 25 feet away from any witness. Everyone was wearing masks, and one of the roles is to weigh credibility of the witnesses. And how do you do that when this is all you see from 25 feet away? You see eyes blinking. And at the end of the day, in your case, I could see the witnesses, whether they were in St. Louis or in California, on my 32-inch screen. And in arbitration, weighing that credibility is important. And I think it made a tremendous difference, and especially having the Zoom arbitration hearing, and then a week or 10 days later, having it in person. While there was some niceties of being in one room, we still had to juggle things like exhibits. And maybe we'll get into that in 1 second, but Steve, can you tell us a little bit about your case and how did that come about, and how did you end up in a Zoom arbitration?
Well, it sounds like somewhat same story about where things started and where things then ended. Mine was a nursing home case pending in Jefferson County, and we filed a motion to enforce arbitration pursuant to our admission agreement. It was a non-wrongful death case. They're not, well, not obviously, that some people don't know, they're not enforceable in wrongful death cases. We went up and down the Court of Appeals for a year or so, and eventually it was affirmed that we were going to be in arbitration in the case. We then reached an agreement on who was going to be our arbitrator. We can talk in more detail about what happens at that point in pre-arbitration meetings and things like that. But we did have all of our pre-arbitration meetings. We did our discovery. We got an arbitration date, and then something hit, and that was called COVID. And that kind of put the end to the date. We continued it a few times, and then eventually our arbitrator said, I don't know when the end is in sight. We're going to need to get this thing scheduled by Zoom. Now, I will tell you that at one point, before we agreed to do it by Zoom, we agreed to do it in our courtroom here in my office. We have a large courtroom. We could all be plenty of feet away from each other. However, we were still going to be having to wear masks. And that was as best that we could do. I didn't want to do a Zoom arbitration. I will tell you, though, that exactly what, Rob, you just said, the credibility in our case was incredibly, incredibly important because of the issues involving either it happened or it didn't happen. It was a series of sexual assaults. And, looking back on it, as much as kicking and screaming that I did to do it by Zoom, it was the right way to go because our arbitrator needed to see people's faces.
There are some who have said the three most important things in litigation and in arbitration: credibility, credibility, and credibility. And, you can have facts and you can pound facts, or you could have the law and pound the law. If you have nothing, you just pound. But having credibility with your witnesses is critical, and it doesn't matter the type of case. Why don't we chat just a little bit? Paul, how did, so once you all knew that we were going to be virtual and conduct it by Zoom, there's some preparation that goes into that that is different than if we're all live. I will share with everyone that Ryan, your office was kind enough to deliver to all three of the arbitrators a 3-ring notebook. That was the largest I've ever seen in the history of the universe. It had to be 5 inches, and you had 2 of them. And Paul, you had just one of the exact same size. Yours was white on the outside, and the Carmody's were black. I don't want to read anything into good or evil or anything of the sort.
Well, in condemnation, the condemnor is always the dark side of the force.
Oh, I see. Okay.
It was not coordinated, though, but I'm glad it turned out that way.
It did. Tell me about your experience in being able to utilize your exhibits through the share screen option, and also getting together to come up with some joint exhibits.
Okay. And Ryan, if you want to jump in at any moment, please do so. I want to back up a little bit and discuss, because Steve was just talking about the pre-hearing scheduling and everything. We of course did that electronically, and that was just smooth. Because we had this set, and then we had to have it reset, and we had to have it rescheduled for various reasons, and we just jump on Zoom calls and have it resolved. And it was very nice. That part of the process, the Zoom component of it, was terrific, because we were able to have a meeting and talk to each other and see each other and work things out. In that sense, I will say, having Zoom or some other kind of video conferencing is a vast improvement to just doing a phone call or trying to get everybody together in the same room. As far as preparation, it wasn't that different sitting down and looking at the exhibits to try and figure out, what did we want to have in advance. There was an extensive discovery process that went on, and we were jointly motivated to get this resolved. And so we were trying to be as open as possible, I think, on both sides. There wasn't a lot of dispute over documentation. The dispute was over the money, was over the value. And so there wasn't a lot of argument over the authenticity of documents or the relevance of documents. And so putting it together was not too different than getting ready for an arbitration or a trial or mediation. Now, when it comes to presenting it through Zoom, where you're using the screen share, that's where you, of course, divert from a live presentation. My experience was I was doing this by myself. Excuse me. I had just actually lost my assistant a couple of weeks before the arbitration, so I was really flying by the seat of my pants as far as the fact that I was just the only one doing it. I know Carmody McDonald had it. Ryan and Jerry did this together. I think they had a paralegal assisting. And so it was very straining to be doing the actual presentation at the same time as doing the actual cross or direct. And I want to say one thing here, and it's a theme I'll probably come back to over and over again. There's a lot of opportunity for mischief here. When you're doing this by Zoom, you can coach a witness to, you're trying to present a document. You say, do you see where I'm at? And the witness can be very difficult. Oh, I don't know where you're at. Well, I'm on this line. Oh, I really don't see it. It's too small. We did not have that with any of the witnesses on both sides. Everybody acted extremely professional. I knew I was dealing with professional counsel on the other side. And so I think if you're going into a proceeding like this and you're dealing with counsel on the other side who you either by experience or through reputation know has maybe a penchant for being mischievous, or maybe a witness that has a reputation for being extremely difficult and non-cooperative, you may want to think twice about how you go into the proceeding.
Paul, that's really an important point. One of the things we attached in our materials, the National Academy of Arbitrators created some materials for arbitrators to use with counsel, and a couple of their instruction sheets, as well as a checklist and some other things we've included in the materials. But one of them I think touches on your point, Paul, and that is that one of the challenges, because we're dealing with folks who are looking at a camera in a remote place, as arbitrators, we don't know what's on the other side of that camera. We don't know, is there a phone recording things? So there's a question of confidentiality. We don't know if they have their notes sitting in front of them outside of the purview of the camera. We don't know if there's someone there coaching them. So one of the things that is in a kind of opening statement for arbitrators is to make an inquiry of the witnesses to make sure that they're alone, they're not to look at their notes, they are not recording, that this is confidential, that something as simple as you should pause after the question. Sometimes because of Zoom, there's a little bit of a delay, and it also gives the opposing counsel the opportunity to object. So those are a couple of things that are a little bit nuanced about Zoom that we wouldn't do otherwise. But you're right, we had none of those problems in that particular case. Ryan, your thoughts or perspectives?
I actually like the screen sharing almost better because I felt than being live, because I felt when you pop something up on the screen, everybody's looking at the same thing and you're directing everyone to look at the same thing. And you could see that the other people are looking at the screen and your exhibit, number one. Number two, it cut costs, and everyone does things differently, obviously. And one thing Jerry likes to do is, have demonstratives and have blow ups. And you don't need that when you're doing something via Zoom, because you can blow it up yourself and you can, manipulate the screen or the PowerPoint to look however you want it to look. So that is an aspect that I really thought was so much better. And you can highlight as you're going, here's, like Paul was saying, here's what you're looking at. We did have a paralegal in there, which was helpful. And I think there were times where Paul was like, give me a second, I can't find it. And we were like, oh, we have it right here. We'll just pop it up, because we did have extra hands on deck. I also think in this situation or these situations that it's maybe expected that we may have some technical issues. So it's not as, heart stopping as when you're in the middle of an arbitration or in the middle of a trial and your technology goes out and you're like, why isn't this popping up? I mean, I think there's so much more patience with this because it's new for everyone. So it almost seemed like everybody had an understanding that it's fine. If there's a glitch in the technology, if you can't pull something up, we'll take a minute and we'll smooth it over. So that kind of takes some of the heartburn away, I think.
Yeah, and we had a little bit of that. I think with the way that, and I want to talk a little bit about the difference of how I presented in terms of where I was physically, like Rob, you just mentioned, you saw me at this chair for 3 days versus how they did in Carmody. I'd like to hear some insight on that. And so we're going to get to that. But that goes back to my point, Ryan, is we were acting very professionally. Not all attorneys do that. And if I was fumbling with something, again, we had a lot of, Rob, unfortunately, the book, all the documents I gave you were probably inclusive in the documents they gave you. We just simply had not done a joint presentation of exhibits. But it was just done professionally. I couldn't find something. Ryan, you just used it. Oh, here's my exhibit A versus your exhibit 2, and let's just move on and get this finished. And Rob, you had mentioned one time there was, if you recall, there was one witness during cross where she was really kind of stunned and taken aback by some of the evidence that was presented on cross, and she very innocently was and I didn't even catch it, that she was looking up something on a database, and one of the arbitrators caught her and said, "Ma'am, are you looking at something?" And of course stopped her so she could. And there was nothing wrong with it. I didn't even catch that she was doing it, but it is one thing, and I had some notes in here to discuss this, is exactly how you described it. You don't know what's on the other side of that camera, and there's ways of establishing the with a witness, where are you physically, what address are you at, who is in the room with you, are you in any way being communicated through any kind of text, through a headphone, or any other manner whatsoever. And as long as then you establish it, and then you say, if any of that changes during your testimony, either before or after, during breaks, let us know. But I didn't feel the need to do that during ours, because I just felt we were dealing with professional witnesses.
Totally agree.
One thing I can say, just as a practical standpoint, especially when you're dealing with a panel of 3 arbitrators, when one of the lawyers says, okay, to the witness, we're going to present, hand you what's been marked as exhibit 37. And at that exact time, all of the arbitrators are grabbing their notebook. Oh, wait, it's the wrong volume. Now they're going to get the other volume. Then they're going to turn to 37 and these massive things. And it's like, okay, go ahead. And we never had to do that because it was on our screen. For me personally, I opened up the books about 3 or 4 times, maybe put a couple of yellow stickies on a couple of the key documents, but I had notes as to what exhibits were what, if I wanted to go back and look at them. But in terms of speed of the presentation, I thought it worked better than being in person in many respects. And I think from a kind of nuts and bolts perspective, an advocacy perspective, you have the opportunity to take a document and then zoom in or highlight in yellow a key section, which you can't really do when it's in person and you're looking at a notebook. Steve, in your case, did you have, were all the witnesses right here, or did you have folks just testifying from wherever they were, their home, their office, et cetera?
So the way we set it up is I was still in our courtroom with my witnesses and my clients. The arbitrator was in her home, in her kitchen, and plaintiff's counsel and the plaintiff were at another location. In addition, I had my general counsel for my client who was in his office in New York. And that wound up being our setup. Ours was not document intensive. I mean, there was some sharing of documents that we did, but we probably only had less than 10 exhibits that we both used throughout the 2-day arbitration. We did obviously, share those in advance, gave the, copies. Doesn't sound like our folder was quite as big as theirs, but we did present that to the arbitrator in advance. I had an IT team available here at the firm in case I needed them, in case there were any glitches, because you're always going to have glitches. But I will tell you, we had no glitches at all. And you're talking about, 1, 2, 3, 4 different locations, and we had no issues at all.
How long was the hearing?
It was 2 days. It was 2 full days.
Okay.
I will touch on a couple things. I mean, you talk about you don't know what they're looking at. One of the things that that you can do is each of you, show everybody the room. Take a camera and show is there anything that might be behind the camera where the witness is going to be looking. We had a wall. We have the OWL system in our courtroom, which are the cameras that they move based upon what they hear. And that's, that works very, very well. But you also, there's a lot of things that you have to take into consideration. You got to take into consideration the framing of, where the witness is, where you're going to sit. I mean, when I was presenting my witnesses, I was sitting at the wall so that my witnesses are looking straight into the camera, and so they can hear me. I mean, everybody on there can hear me, but she's looking or he's looking straight at the camera, and that's one of the things that you got to consider. There's a variety of things that have to be considered, but how much are we going to be doing Zoom arbitration in the future? I hope a lot, to be honest with you. Presenting in a one-dimensional format like that was pretty scary to me, but going back and looking at it, I thought it was in some ways even better than being in person, if nothing more than my witnesses, it was a very troubling set of circumstances. They felt more comfortable being in an arbitration by Zoom than being in the room. And frankly, they didn't want to be in the room with the plaintiff because of the dislike towards her. So it worked out really well. But and maybe we'll talk about this near the end here, but whether you're doing Zoom arbitration or just plain old, in-person arbitration, I think it's really important. And I think it's for the future, if nothing more, and Rob, we talked about this I think yesterday, nothing more than our court systems are going to be backlogged for a long time because of COVID. And yes, there's advantages to arbitration. Yes, there are disadvantages. You've got appellate issues. Every case is different, but there are a variety of reasons why arbitration, like Paul and Ryan did by agreement, I think needs to be looked at more often than it is.
One of the standard benefits, if you ask what are the benefits of arbitration, in theory, it's faster and less expensive than traditional civil litigation. I think it's important to, and I probably should have started with this, is Ryan, Paul, Jerry, someone picked up the phone and called me, I believe it was the beginning of October, and said, look, would you be willing and are you available to hear this by the end of the year and to issue your ruling? That there were some tight time limits that you all had negotiated. That was, we bumped the deadline by, I think, maybe 2 weeks. But at the end of the day, this thing started with a phone call. Can we arbitrate this by agreement? In the beginning of October, 2.5 days or 2 3/4 days of hearing in mid-January, and the decision was, I think, the day after we finished the testimony. So ballpark about 90 days, start to finish. And certainly I can envision there are some cases that are not ripe to go to arbitration. But in commercial cases, if all the civil cases are going to stand behind the criminal cases for the next 18 months or 2 years or however long it's going to take, certainly there's a benefit of teeing these things up. I would think you all are the practitioners. I'm no longer doing that. Ryan, what do you think about cases going forward?
I would personally just suggest doing what we've done, because what Steve said, certainly everything is backed up. And I don't even, a lot of our cases, as the courts are saying, don't take precedent because they're not criminal. Our people aren't in prison or jail. And so this was a really effective way of doing it. And if you don't want just one arbitrator doing it, I thought the panel of 3 was good. I really liked how you chose, one person to kind of make the decision and then move forward. But I will tell you, in the same case, we did an in-person arbitration the following week, and it took longer. I just felt like this was such a better forum for what we needed to get accomplished. And I do think, as Paul, all of us were nervous about it. As Steve said, at first, you're saying, I've never done this. And especially for someone like my dad, Jerry, he likes to be in court and likes to be in person. But I would suggest this to anyone as a way to move cases.
It is interesting to me that you had your case. As I recall, Jerry was the one, I think, who told me you had a status conference and the court said, yeah, I know you've got a trial setting, but it's not going to happen. And all of us, probably most of us on this Zoom have experienced the same thing. So, what alternatives are out there? Paul, what do you think in terms of the future? Are there cases that you can envision in your condemnation eminent domain practice that you could see utilizing this same type of process in the future?
Yeah, last summer, 2020, I remember talking to other attorneys, and it was just as everything had shut down, and there was this discussion of having arbitrations, mediations, and trials, even jury trials via Zoom. And at the time I heard something like that, it just kind of blew my mind. There's no way this is ever going to happen. Never did I think that in about 6 months' time from that period, I would be doing a 3-day arbitration on a very high stakes case. And I particularly did not like the experience. Let me just say this. I found what you call Zoom fatigue, staring at a camera with all the different faces facing at you, excuse me, for 3 days was so much more draining than even a jury trial was. It was really, to me, it was very difficult. Now, having said that, I think doing a mediation purely via Zoom, which is a much more relaxed type of procedure, would probably be certainly acceptable to me, especially when, like in our case, and I think in Steve, his general counsel was in New York. My client they were all in California, and they were able to testify without having to do travel, definitely expedited matters. And so definitely some form of hybrid version of that would be acceptable to me going forward, where witnesses, even witnesses who are in town, simply don't want to, maybe make the trek to a mediation facility. But my preference would be to not do it purely by Zoom. However, like Ryan said, I wouldn't want to do it in a room where people were all masked up.
I also do think, maybe it's dependent on your circumstances. Jerry and I were tag teaming, and, I was taking some witnesses, he was taking some witnesses. And so, but Paul, and like I said, we had a paralegal or sometimes two sitting in there with us. We were in a much larger room with a screen across the room. So we didn't have our computer just in front of us. And I wasn't just staring at, a monitor all day. It was more spacious, I would say. So for me, I really enjoyed it because I wasn't, like Paul's saying, I was sitting in a chair doing it alone. So I also think it might depend on the circumstances of, where you are and what you're doing.
Steve, tell us your thought in terms of the being forward-looking. Do you see us going back to just in-person hearings, or could you envision once, for example, if everyone is vaccinated, our office will do in-person hearings, okay? And if not, we ask for everyone to be masked. That protects everyone. That's just part of the safety protocol for all the participants, for the arbitrators, the mediators, the staff, et cetera. Do you see, Steve, an opportunity in the future where we will have that hybrid, where your general counsel doesn't need to get on an airplane and fly to St. Louis for a hearing, but could participate by Zoom?
Absolutely. And not just a client, but experts. So I do see probably more of a hybrid that you're talking about, and Paul is talking about as well. I wouldn't be concerned about doing another Zoom arbitration tomorrow, to be honest with you. I'm such a believer in it. However, I don't think that a strictly Zoom arbitration is here for the future. Arbitration, though, I want to just touch on that from my perspective. All the positives, the savings, the cost savings, and the time savings in discovery. It's I think it tends to be more focused discovery, and if one party or the other is not being focused, when you have an arbitrator or an arbitration panel, you essentially have a discovery master at your beck and call, and you don't have to wait in line in the court system to have your discovery hearing. So I think that's helpful. There are sensitive issues in trials that people would prefer to be in an arbitration and not in a public forum, so that everybody can see this issue that is very sensitive and personal to one or both parties. The other thing to consider is, look, there are some people that call arbitration sort of binding mediation. That their arbitrator is really, in the long run, they're just going to split the baby, and is it really, is it worth that exercise? I will tell you, I have arbitrated 2 nursing home cases, and I've gotten I want wins on both of them. I'm not tooting my horn. I'm just saying there wasn't binding mediation in those 2 cases. But, I can envision, cases kind of like what Ryan and Paul had, where you're not really talking about the standard of care. Does one party owe money or not? They do owe money. And, and I have cases where if I think, I'm going to lose the standard of care, it's just a question of the damages. In most circumstances, I would rather have, an arbitrator or an arbitration panel making that decision than a jury of 6 or 12 who might look at things a little differently than certainly an arbitrator would.
So, Steve, in your case, did you have set up in your scheduling order disclosure deadlines for exhibits, disclosure deadlines for witnesses, and during what do you say, 4 days of hearing, would you or your opposing counsel share the sequence of who the witnesses would be? Like, at the end of day 1, tomorrow we're going to have witness, Susie Smith, followed by so-and-so, just as a courtesy to opposing counsel. Give us a sense of what you had.
Yeah, sure. At my request, we essentially did a scheduling order that is very similar to what you would see in the circuit court or in federal court. It was the identification of expert witnesses, dates by which they would be deposed, close of discovery, sharing of exhibit witness lists, which you're really not entitled to in Missouri, but we agreed that we would do all of those things in advance. Those were all done in advance. At the time of the hearing, we sort of informally said, look, here's who I'm going to start with, and who's going to be next, so that everybody was sort of on the same page, and tried to make it as seamless as possible.
Ryan and Paul, because you had a number of witnesses each, so were there differences on how you approached your preparation with your witnesses, knowing they would be appearing by video as opposed to, being on the witness stand and being sworn in person? Ryan, you want to start with that?
Sure. I mean, we did our normal approach. It's just that we didn't meet in person. I mean, this was before vaccinations, and I think people were definitely concerned about COVID being an issue. So we did everything via Zoom, and we prepped them just as we normally would. I believe that we sent them documents that we wanted to go over maybe in advance, and then just pulled them up on the screen when we were, discussing them. But there wasn't anything different about what was said. It was just kind of the way that it was communicated.
Okay. And Paul, you mentioned your witnesses were primarily in California. What was that like, trying to prepare them from 2,000 miles away and to have them appear by video?
Like Ryan just said, it was from a procedure point of view, it was very, it was very similar to preparing a witness for a trial. You just aren't sitting in the same room, and you're showing them, here's the potential documents that I could show you. Here's some potential cross issues that you might want to be able to be ready to deal with. And so it was really very similar to how you would get ready for trial. But I'll say one thing I want to get in here before we run out of time. So when I did it, I just expected, and how I did it was I sat here in my chair and I presented my evidence. Now, what Jerry and Ryan did, and I found this to be very, very impressive, and it surprised me. They had a big room with the big screen that they were looking at, and they stood at a podium to present their evidence. And I thought, wow, it recreated that feel of being at trial or presenting evidence, or even maybe arguing something in front of a court. And I really just thought it just looked easier to do it that way. And I wish I had anticipated. I'd love to hear from Ryan how they came up with doing it that way.
Well, that was Jerry, because he was not a huge fan of Zoom in general. I mean, I remember when we were home at the beginning, he would call and say, I am incompetent. I can't figure this out. And so I can't wait to get back to court. And then when we all determined that it was just a bad time to be in person, he, one of the things he likes to do, if you've ever tried a case against him or with him, is, and so do I, is move around, be standing up. We'd use our hands a lot. And I think he was concerned that part of his showmanship or the way that he presented would die via Zoom. And so we just thought, if we had a podium, a table podium where we could then stand, and it would be just like in court, you could feel more comfortable like you were in court. And that was kind of to put him at ease, but it really ended up, like you said, it ended up working out, because we would take turns standing up there, and you did feel like you had that in-person courtroom feeling as much as you could, over a screen. So
you allowed Jerry to be Jerry.
Correct.
Right. And that's the feeling I got. And I have tried a number of cases with him. And I do think if he had done my approach, a lot of the Jerryism would have gone away. And I say that in a very, respectful way, because it's effective. And also by moving around, you get rid of some of that adrenaline that as I'm watching my witness getting cross-examined with a piece of evidence I didn't expect, right? The adrenaline's building up. And I'm not, doing like Jerry or you and just moving around, even just standing, letting the blood flow. And I thought that was very effective. It had a little bit impact, I think, on the sound, but at the end of the day, that didn't matter. You just look more at ease, and and allow Jerry to be more the way he is. I have experienced him in the courtroom.
Well, good.
So.
Thanks. I'll tell him you said that, Paul.
Steve, let me ask you this. In your case, what was the experience in terms of objections on evidence? And I'm asking the question for a reason, but I'm trying to get your sense. Were the rules of evidence followed, or was it like a lot of bench trials where I'm going to let it in and I'll give it the appropriate weight?
No, it was, the rules of evidence were followed. Our arbitrator was a former judge, and so it was as if we were in the courtroom. And we actually had some objections that related to certain exhibits as well, but most of the exhibits, we just agreed on authenticity and relevance, everything that came in, and that wasn't an issue. But we did have objections to testimony. Some I won and some I lost.
And as I recall, in our case, Ryan, correct me if I'm wrong, but I think early on and it was myself and two retired judges, circuit judges, said that because one of the grounds to vacate an arbitration award is that the arbitrator failed to admit evidence pertinent and material, that we're sitting there in the middle of a hearing trying to predict later what the trial court might do on a motion to vacate, saying, okay, was that evidence pertinent and material? We don't know what that might be. So for the most part, the decision-making was, well, we're going to let it in and we'll give it the appropriate weight. And I think we shared that with both sides. So you knew going in, it's pretty much all coming in. And oftentimes that's what we will share with new arbitrators when we're doing some trainings.
Yeah, but I felt like Garvey hit me a couple times and was like, explain where the heck you're coming from. But that's probably from trying cases in front of him. But I do think that he did stop me a couple times when Paul objected and was like, tell me why you think that should come in.
Yeah, I think he did that a couple times. And again, it's his nature of long time being a judge.
Right.
I don't think any of it was super critical. And again, on that case, Rob, if you recall, we did not ask for a reasoned decision.
Correct.
You just gave, that's why we thought we can get a quick number from you. We didn't ask you to go through, explain yourself, just do like a jury, fill in a number and give it to us. And that's what you did. And
Paul, that raises a good point, because going to the benefit being quicker and less expensive, the quicker part is you can turn around that type of standard award as we did within a day. Standard award is who wins and how much. A reasoned award is the who wins how much and why, with some rationale. And what some of us are used to is that, formal findings of fact, conclusions of law. Well, arbitrators are always happy to do that. Although more often than not, we'll be asking the lawyers, hey, will you submit a proposed set of findings and conclusions? That increases the cost. And frankly, I wonder at the end of the day, is that really beneficial to you? It might give you a sense of why we decided what we decided. But in your case, I think it was pretty straightforward. You're looking for the value. So we've got a couple more minutes. Ryan, anything kind of last minutes thoughts that you had?
I wanted to tell you that my paralegals said that the best part about doing this via Zoom was that they didn't have to lug all of the binders you're talking about to one place, that we were in one place. And so we had basically the documents that, it's easier when you're at your office. And if you forgot a document and you're in the city of St. Louis and running home, like you can look it up, you can email it to the arbitrator, you can email it to opposing counsel. And so their 2 cents when I asked them what they thought about it was that it was just nice to be here. And also nice that if you're moving ahead and you're moving quicker than you told your witness, you could just call your witness and say, you're going to be on in 5, and they could log on rather than driving, and everybody waiting around. I felt like it was a quicker process because you logged on at 9 a.m. You weren't all getting to a place, chatting for 30 minutes, getting yourself situated. When you logged on, you were ready to go, and we went. And so, and I think that's how it was very efficient.
One thing about witnesses we didn't mention, and that was that witnesses who logged in while we were finishing up on witness number 1, witness number 2 would log in and would remain in the waiting room and be sequestered. And then once we finished with witness number 1, we would admit number 2 and they would come in, the other would be excused. So it was a way that we could sequester witnesses. Paul, any final thoughts?
No, I mean, I hadn't thought about that, but actually it was very nice to not have to carry, because I like really big exhibits. And so, not have to carry those and your trial folder and that phasing of witnesses, because I really, it's very distasteful to have to pay an expert who's charging $300 or $350 an hour to sit out in the lobby for 2 or 3 hours because you're going late. And boy, I really dislike drawing the ire of a judge when I finish up with a witness and he says, call your next witness. And I say, well, they're not here yet. And the jury's sitting there. And so you end up having to pay that fee of them sitting out there. So it was nice just having everybody lined up and ready to go.
Great. Steve, any last minute thoughts?
Just to tell you that, my general counsel, of course, he wanted it in person, but he also wanted it to be in person, after COVID. He wasn't going to get that. So the thought of it, he went also kicking and screaming at the same time, February, not many people were vaccinated. So the fact that he didn't have to get on an airplane and travel here, even though we would be wearing masks, was welcomed by him. But I will tell you that after the process, he is a true believer that a Zoom arbitration, and he does arbitrations all over the country for his nursing homes. He's a believer.
Very good. Paul, Steve, Ryan, thank you so much for your participation, sharing some nuts and bolts and practical tips to our attendees, and we appreciate your expertise and giving your time.
Thank
Thank
you.
you. And thanks for everything, Rob.
Thank
Yep.
you all.
Thank you.
So
Thank you.
folks, we're going to take 5 minutes. We'll get started with our next program at 3:40. So let's start our next program. Over the past several years, there has been a lot of work done by folks in the St. Louis area to help try to resolve housing cases. And I had this conversation with Professor Karen Tokars, who's going to moderate today's program. Karen is the head of the negotiation and dispute resolution program at the law school, and really a moving force in this area in our community. And Karen's going to introduce the members of the panel, and we'll go until 4:30. I'll give you a 5-minute warning.
Right.
Good. Karen, thank you.
Sure. Good afternoon. As Rob mentioned, I'm on the faculty at Washington University Law School. I have to apologize. There's construction going on in my street in the background, so I hope it doesn't make too much noise. I do direct the negotiation and dispute resolution program and the Civil Rights and Mediation Clinic, and I'm the president of the St. Louis Mediation Project that we're going to talk about a little bit more in this program today. I want to start with a huge thank you to Rob Litz and to Mike Geigerman and to USA&M for hosting today's CLE. But as many of you know, USA&M has been providing low cost, almost no cost CLEs as a public service to Missouri and Illinois practitioners, for which many public interest practitioners I know are extremely grateful, but for well over a decade. And we are really proud to partner with them on today's program and other programs throughout the year. They're always just wonderful and wonderful to work with. And thanks to the staff at USA&M too, who really are the mainstay. During this particular segment, which is the 7th segment in today's program, we're going to discuss, as Rob mentioned, the current eviction crisis and mediating and resolving housing disputes, specifically through mediation in evictions. And evictions are a big issue, always a big issue. And as many of you know, though, it's becoming a growing area of concern and litigation during COVID. If you're following the issue in the news every day, there's some new piece of information. Today, for example, the CDC just issued this morning an extension on the temporary halt on residential evictions designed to prevent the spread of COVID until the end of July. And this will probably be the last of the extensions. So as Rob said, we're going to go till 4:30. He or I will give you a 5-minute warning before we conclude. We have with us today for this particular program 4 experts in housing law, policy and practice, particularly mediation. Lee Camp is with us. Lee is senior staff attorney at Arch City Defenders, which, as many of you know, is a civil rights nonprofit firm here in St. Louis. Lee is one of the top housing law experts in the Midwest. He's somebody I frequently go to for advice. And he litigates in state and federal court in lots of cases that are high profile cases, housing discrimination and eviction cases. And in the materials, if you can weave your way through the materials, you'll see towards the back, the Arch City Guide on Evictions. It's targeted for individuals who are facing evictions, but actually it's quite helpful for attorneys. Should you find yourself handling eviction cases, either for tenants or for landlords. We also have with us today, Julie Ostrom from the Stock Law Firm, where her main areas of practice are commercial real estate transactions and landlord-tenant litigation. She previously worked as in-house counsel for a real estate development company. We have Josh Schindler from the Schindler Law Firm. He represents clients in a wide range of industries, including nursing home, construction, low-income housing companies. His clients include community care centers, elder law management services, and McCormick Barron Management, which we'll talk about a little bit later. And last, we have, I hope, Elon Gross, who is somewhere out in the mountains in Colorado. Welcome. The outreach coordinator for the St. Louis Mediation Project. He's an expert in civil rights and government transparency. He frequently represents nonprofits, small businesses, and citizen groups. In the last year or two, I think it's safe to say he's become an expert on eviction law and policy, and including local, state, and federal government resources for tenants and landlords, which are huge to the resolution of this issue. He is spearheading a St. Louis Mediation Project initiative that he is going to talk about a little bit with Josh to generate out-of-court pre-filing eviction mediations before cases get into court, which is a way to save time, to save costs, to save risks for not just the landlords and the tenants, but also for the community and for the courts. It's also a way to help facilitate this distribution of local, state, and federal funds, which are crucial to the resolution of a lot of evictions. So I'm just going to say a few more words about the mediation project in a minute, and then we're going to have basically 2 segments. The first will be a short conversation between Lee and Julie, sharing their insights about landlord and tenant perspectives in the current eviction crisis and what they see as pros and cons and optimal avenues for resolving. We'll do a little bit of Q&A, and then we'll have a short conversation for about 10 minutes between Elad and Josh about this new pre-filing eviction prevention initiative, which is getting off the ground here in St. Louis. And we will conclude with questions to the degree we have time left from the panelists and the audience. So just a few more words about the eviction crisis and the mediation project to put this in context. Some of you may have seen a short article about the mediation project in the most recent St. Louis Bar Journal. It's included in the materials. It's just following the arbitration materials from the last segment and just before the Art City materials I mentioned. You know, everybody knows that US is currently facing the most severe housing crisis in history. And we have an avalanche of evictions still to come. The numbers are staggering. According to the latest analysis of US data, an estimated 30 to 40 million people, up to half of all American rental households, are at risk of eviction. The numbers are shocking. Evictions in St. Louis City and County, not surprisingly, mirror this harsh nationwide eviction landscape. Even prior to COVID, nearly 16,000 eviction lawsuits were filed annually in the city and the county on an annual basis, an average of 43 eviction lawsuits per day, and the costs of which are borne, as I mentioned earlier, not just by tenants and landlords, which is how we tend to see the picture, but also the ways in which eviction impacts education, crime, public health, housing stability, and the courts. COVID has just taken eviction to new heights. The catastrophic job loss and unprecedented unemployment rates have exacerbated the situation. So about a dozen years ago, at the request of judges in the St. Louis City, the mediation project evolved. It was after a number of people had been pushing the courts and pushing the government to provide lawyers for all tenants in eviction cases, which some cities have done. St. Louis chose not to. But the government and the courts were urging this idea of doing mediations, at least in pro se housing court. And from that, the St. Louis Mediation Project emerged. And law students and volunteer lawyers from USA&M and other places started doing mediations in St. Louis pro se housing court every Friday morning for almost a decade. And we shifted to the county about 3 years ago. And as I mentioned, now shifting more into the community. We've also worked during this period of COVID with the county to transition to Zoom, not just for the pro se housing court, but for all of their dockets to help them create, as some of you may have seen if you're back in the building, the Access to Justice Center on the first floor of the county courthouse. It has 10 kiosks and computers and staff there to assist litigants with whatever kind of case they have, and also to work with the county government to open the new North County Satellite Court, which also has 10 kiosks and computers that are used for mediations in housing court and for other resources. I like to share with people who don't realize, and maybe do, how difficult these times are for many folks. During the first 10 weeks that the center was opened in the county courthouse, there were 940 users. No advertising whatsoever, just people walking in the door, needing access to justice, access to the courts, litigants of one kind or another, need an order of protection, have a divorce case, have a small claims case, have a small associate circuit criminal case, civil case. There were even 6 weddings that in the first 10 weeks on these kiosks on the first floor. So that shows you how much usage there is among people, how much need there is to access, and how mediation has been really played a significant role in this evolution of coping, the courts coping with the crisis. And I'm sure during different, you've noticed it as different people have mentioned throughout the day, the realities of doing mediations and arbitrations and negotiations and client interviews and all other facets of lawyering has multiplied considerably, and much of which is quite likely to remain. So I'm going to transition here. I'm going to ask Julie and Lee to take over and to talk about and share with us their expertise about landlord-tenant perspectives, about the conflicts, and about avenues for resolution. Lee, Julie, thank you.
Yeah, Julie, I think you should start it. Let's start it like a lawsuit from the landlord's perspective.
Yeah, I'm the big bad guy here in this
Yeah.
one. Right?
Well, I don't see any of our fellow practitioners in this area of the law on the call, so we should be in a safe space.
Right, well, hopefully, right? So I'm Julie Ostrom. I've been representing landlords in eviction court for over 10 years. Been a bulk filer in St. Louis City and St. Louis County. And I can say I've been on the program all day today. It's been really informative and interesting, but landlord tenant disputes are very different from civil litigation. These housing lawsuits are summary proceedings that include a right to an expedited hearing. So the statutes provide for very limited remedies in order to resolve the disputes quickly. And there's rarely any discovery, and most of these matters are literally filed and concluded within 60 days. So 2 causes of action that a landlord has when they have a dispute with their tenant is a rent in possession and an unlawful detainer. The rent in possession is very straightforward. The tenant's behind on rent payments. The landlord can file that action immediately to collect the past due rent and obtain an order for possession of the property. If the tenant pays the rent that's owed prior to the first court appearance, the lawsuit is dismissed. So that action is literally about money. An unlawful detainer action, though, a landlord has to take steps prior to filing. They actually have to terminate the tenancy by providing notice to the tenant and giving a specific amount of time before they can file that suit. So this usually is a result of either terminating a month-to-month tenancy or a notice of a non-renewal of a lease, or in some circumstances, termination because there's lease violations. So I will just say openly, most landlords do not like mediation. And I think a lot of people look at landlords as though they are rich people that own this unencumbered property, but most of my clients own less than 20 properties. They have mortgages, they pay the water bill, they pay the sewer bill, they pay insurance, they pay the property taxes. So it affects them financially when a tenant doesn't pay rent. And by the time the parties get to court, the most important thing to stress about this is that they've already had a number of communications regarding the issues that brought them to court in the first place. So if the landlord hasn't received rent, filing an eviction is a last resort because they're already in a situation where they have negative cash flow and they have to pay the attorney's fees up front to file. In the case of an unlawful detainer, especially where the tenant has violated the lease, there's been a lot of communications before the filing. So once we get to court, there's a lot of issues that come up and problems for mediating these types of disputes. If it's as simple as sitting down and working out a payment arrangement, that might be something that is easily resolvable, but oftentimes the parties' communication is completely broken down by the time we get to court. And the mediator themselves are not dealing with usually just a simple payment arrangement, but sometimes behavioral problems as a result of the tenant or the tenant's guests. And I think this is polarizing for any mediator that handles the housing and the mediations I've been a part of, because from file to file, 100+ cases in a day, everything is different. And I also think that mediation is interpreted as an opportunity for the tenant to have more bargaining power. But over the years, and COVID pandemic aside, I think that a common settlement that always existed would, my client was willing to forego thousands of dollars of past due rent in order to just get a judgment for possession of the property. And Lee and I have negotiated many of these agreements over the years. So when you get down to the mediation table, oftentimes it's a he said, she said argument. And the tenant will sometimes raise issues the landlord has never heard before. So this buy-in that's required in a mediation can become a real problem in housing disputes because the parties will sit and butt heads and the mediator sometimes hands are tied. And a mediated settlement often isn't attractive to a landlord because it keeps a case open, right? We might continue the matter, negotiate some sort of payment arrangement. If the tenant performs, then the case gets dismissed. But the landlord doesn't have any verification that if that tenant violates that settlement, that they'll be able to get possession of the property back, which is ultimately what they want to stop the damage from continuing to occur. All right, Lee.
All right, thanks, Julie. I would totally agree with you there. I mean, it's a last result for the landlord, and certainly, my name's Lee Camp, by the way, and I represent tenants exclusively. So It certainly is the last resort. I think that everyone agrees, like when we get to the eviction process, there's been a lot of loss on both sides for one reason or another. And we certainly want to avoid that. Julie gave a great context of what we see. Generally, we see the word eviction pop up in the newspaper, and it usually is one of those two type lawsuits in Missouri. I would say 80 to 90% of those are simply over non-payment of rent. And so you may be wondering, so what does someone like me who represents tenants who, are just behind on rent, can't even afford me? I provide all of my services pro bono to tenants right now. And what do we do? Well, there's a number of things that we can do to somewhat level this playing field, whether that is just going and working out those settlement agreements, those repayment agreements. Julie's worked with me long enough that I do usually give something over that gives the landlord assurance that they'll be able to get the tenant out if they don't make their payments, et cetera. But one positive thing we know about attorneys like myself, and we see it in data from around the country, is that tenants have a better shot in court when they do have attorneys. And so that's really one thing that I take pride in my work, is that I know by just being the advocate there's a better chance that we will work something out, et cetera. Or if it goes to trial, that my client is going to stand a better chance than if they had to actually navigate the system on their own. These are pretty confusing lawsuits to pro se tenants, which are, again, 90% of the tenants in these cases, because they do move so fast. It is, very rare in our area of civil practice that we see a lawsuit go from filing to finished in 60 days. So it's difficult to deal with as an attorney. Admittedly, I do deal with those constraints of not always getting discovery. Sometimes it's not even necessary in these cases, but when it is, it can be difficult. Even as an advocate that's been in the courts and before these judges for years, it's sometimes not understood what I'm asking for, why we would need those things. So that's a little bit of what I see. I guess I did want to touch a little bit on what COVID has changed specifically in doing this work. There was always a handful of attorneys that represented tenants in town, and we did our best to kind of, make a dent in the system or change the laws where we could for tenants. Our law is very one-sided. I would argue Julie probably has a different take on this. It's very, very landlord friendly. That is not uncommon to Missouri. That is very similar throughout the rest of the country. And, we would pick and choose our battles. I practiced as a legal aid attorney before I was with Arch City, and I would equate myself to a civil public defender. I did carry that stack of cases into court, and I tried cases frequently in my first few years of practice. But we would pick our battles, those cases that maybe we could take up to the appellate courts and try to change procedure, et cetera, to level that playing field. So that's a little bit of just the day-to-day kind of what I'm looking at. Now, when we do talk about COVID itself, there's never been a more crucial time for tenants to have attorneys. That's not simply based on the numbers or that the non-payment issues that tenants encounter or the law itself statutorily has changed. What I have found myself doing for the past 16 months now at this point, probably closer to 18, is keeping up with the different changes in local laws around eviction moratorium that have happened, a lot of community education around those issues, and instructing clients on what protections they have at the time. Additionally, the federal government has weighed in on this issue back to July of last year. And since that time, there have been various legal challenges around the country to a federal eviction moratorium that still remains in place today. And as Professor Tokar's noted too, was just extended through the end of July. And so we've had to keep up with these rapid changes in the laws that our tenants are using. They are using these protections right now in the St. Louis area, but they never know when they'll expire without talking to an attorney. They're somewhat complicated to actually digest these different issues. And so I've had to use a lot more of my legal skills in a policy way to kind of break down these federal laws that are being handed down, how they apply here locally, but also engaging in dialogue and advocacy with people in the federal delegation, with different advocacy organizations and things like that. It is one of the benefits to being in the courts so frequently As any landlord or tenant's attorney will tell you, we spend a lot of time almost every day in the courtrooms. We really understand this arena. It is informed through the law, but we've learned a lot through the housing law. Other than the CDC, a big thing that I've been doing is working with people like Alad, who's on the call, to funnel people or direct them towards rental assistance right now. One thing that Julie and I've always been able to work out, unless it's a termination case over, someone's behavior or maybe the actions that happen there. If we're talking non-payment cases, landlords are generally receptive. And these hardships that have beset tenants right now have certainly been passed on to their landlords. We now know we're looking at a potential foreclosure crisis, not only an eviction crisis, but a foreclosure crisis, particularly for those smaller landlords that we think of as mom and pops. Even owning 10 properties, can be difficult when you're not getting paid by 8 of those tenants and you have 7 mortgages still outstanding at that time. So we know that those costs are being passed on right now, and it really puts us in a situation of economic instability throughout the housing market. We expect rents to go up as the homeowner market right now is very hot for sellers and tough for buyers. That will certainly lead to rents that go up. And for a community like ours that has an affordable housing crisis in it, again, we're not unique. This affordable housing crisis exists throughout America. But for communities dealing with these problems at an acute level like we do here, there certainly is going to be a lot of instability in this area. So what we are seeing nationally is movement on potential right to counsel in tenant advocacy. What we're seeing is potential right to counsel advocacy. We're seeing new states or cities every day adopting some sort of civil right to counsel akin to the Gideon protections that exist for criminal defendants. And we're seeing a lot of movement towards what we're talking about today. These are diversion, or what they're called diversion programs. Essentially, they're mediation programs, sometimes pre-filing mediation programs. And I'm even interested to hear in the movement that's happening in that here in the St. Louis community. I will agree with Julie, it is difficult as a litigator when I get involved in a case that's done in 60 days. Usually I'm not looking at mediation as a route to resolve that case. It's not a knock on mediation. I've got one next month in a federal case, but it is difficult when you're a lawyer involved in these things to consider mediation. But that being said, we are seeing that these intervention points before the filing or early in the filing can actually be effective, particularly paired with money. So with that, that's kind of my spill. I'll turn it over to you, Karen, if you have any questions for.
Well, I do have 2 questions, and then we'll switch gears. And they comes at the issue from different perspectives. So Lee, starting with you. So I'm a former litigator turned mediator, was very excited about this movement 10, 15 years ago when the city and the county were talking about what other cities like New York and Newark and San Francisco and Denver and Philly have adopted this idea of providing lawyers for all tenants. But it didn't evolve, and it's a little bit percolating now, but it's got a long way to go if it happens. So yes, it would be great if the whole world had lawyers. I think most lawyers can agree with that. But as it is now, over 90%, as you say, of the parties who are participating, who are being invited, quote, to participate in housing court, don't have lawyers. And what we found through, when we analyzed the court numbers, when we ran the numbers for one entire year in St. Louis City, that of 5,000 cases, 4,900 and I think it was 36 judgments for the landlord and 2 for the tenants. So, your chance 0.0 whatever percent that is. So it's not a system that works well. And mediation seems to be a middle ground. The data that we've been running consistently in the city and now in the county shows 70 to 75% settlement. And of those, over 50%, almost 60% compliance, meaning people stick with what they agreed to. So they might not have wanted to mediate. And maybe if the party has a lawyer, there is less need to mediate, but all those other 90% seem to benefit from some kind of mediation. And my question to Julie, and then neither one of you can jump in, is that what I hear more candidly from bulk filers and more than once have heard it from bulk filers who say, I don't want to mediate because it takes too long. I'm being paid $200 or $300, $400 per case, and I can do that case in 10 minutes in court as opposed to an hour. And I've never done a case with you, so I'm not saying that. I'm just saying that there seems to be an investment, and it seems to be a different message from the landlords that we're hearing now when we talk to landlords, big landlords, about doing pre-filing, who say, oh yeah, if I can save attorney's fees and filing fees and sheriff's fees, transition costs, the costs are somewhere between $2,000 and $6,000, depending on whose study you use for any eviction. So if either one of you have reactions, I'm pushing back a little bit on both of you.
Well, I would say, I mean, I'm a big fan of pre-filing mediation. I'm really excited to hear this part of the presentation because I think this is a great move forward. And yes, bulk filers charge a flat fee, and I can see a lawyer looking at it from that perspective. That's never really been the way that I've looked at it, but my parents are landlords. I grew up with, that in my family background. So I see what they go. My parents had a tenant for 23 years. That is ideal. Every landlord, they don't want their tenants to move. They want their tenants to be happy, to take care of the property, and pay their rent on time. That is, I mean, unless you're something that is outside the fold, that is what all landlords truly want. They want their tenants to be happy in the property. So I can see though, sitting down and having to have the landlord say their piece and the tenant say their piece. But I always did that. I went back and looked at my numbers over the years when I was bulk filing. I mean, I had like a 99% consent rate. And we would come up with something that worked, whether it was, I just can't ever get caught up and I need to move, give the tenant a reasonable amount of time to vacate, or let's put you on a payment plan that makes sense. But I took the time to talk to people, and that's what the mediators do. I said, and I had been to a couple of Fridays that you were talking about in the city. So that was a challenge though, for the law students and the volunteer lawyers, because each case, these people they're so emotional that it becomes really difficult to resolve that dispute for a mediator. But I understand, I mean, it definitely takes longer, but isn't ultimately getting the right result for both parties more important than funneling everybody into the hallway and dictating to them what they're going to sign? That's, maybe I don't fit into the bulk filer category very well though. So
I would also agree though on the pre-filing front. I mean, more lawyers are great. I think theoretically, from my perspective, without serious policy prescriptions that change this arena, more lawyers aren't going to help. I mean, they would certainly, we do know that tenants have better results with attorneys, but I would be being a mediator for the most part. Again, I've stepped a little bit away from this in my practice of taking 30 evictions a month, but I take enough, and still that is a lot of my practice is practically smoothing it over with the other side and letting cooler heads prevail. And that is a role a mediator can play. It would probably be much more effective pre-filing. So that would be my take kind of on that question.
Well, let's transition. Thank you. Josh, Eli, can you give us, I know this is on the precipice, we've been doing it for a few months, but just on the precipice of this real partnership with Josh. So Eli, Josh, jump in.
No, this is a great transition because we have been doing mediations, pre-filing, and even while the proceeding is going on. So it's been interesting to kind of see what the differences are. Many times we'll have, attorneys who may have filed something already. And, given like what you said, Karen, in terms of the cost of having an attorney do all of this, instead they say, look, I'll talk to my client and see if they'd like to do a mediation. And for folks who are looking at the situation, which most landlords do, at least from my experience so far, is that they would like to resolve as quickly as possible. And oftentimes mediation, even during the proceedings now, especially, given some of the time it takes for you to get from the beginning to the end, and you get a final judgment, then you have to wait for it to be final. Then you have to get the written, everything else. In that meantime, and I've got some folks who are texting me literally right now about this. Hey, can we get this mediation done? Because I would like them to do X, Y, Z. And so I think that it certainly plays an important role while proceedings are going on to ensure. It depends on the situation, but that's going to be true about pre-filing as well. So we've talked a lot about pre-filing, and the pre-filing ones have been very interesting because I think you've got kind of, this confluence of all of these interests all at the same point, and they would love to resolve this if they didn't have to take this whole long proceeding that they knew was down the pipe. So I've got a couple of things I wanted to share really quickly. Is that a doable thing I'm going to be able to share? I can. Okay. All right. So I'm going to show this. You should see right now a PDF document, and it's a memorandum of understanding. And this is an example of an agreement that we come to. Okay. And so this is one that we do in the community. Oftentimes it is pre-filing. Sometimes we find out that there is a case and just kind of hanging out there. The landlord would like to work with them for a little bit. And so oftentimes, these agreements, they look very similar. The details are often very different. For example, how much rent is being charged, how much is owed, what the payment agreement will look like. And if you just look really quickly at this one, you'll see, oh man, there's a whole bunch of dates in that body of this. What is that? And folks are agreeing that on this date, I'll be paying this, on this date, I'll be doing that. And so we get really detailed into what each party should be doing. And really what we often find is in mediated situations where we're at this point where folks are just disagreeing with each other after having some kind of an agreement where one person is living in somebody else's property and paying rent and all of that for it. That there's some point where that just blows up and folks are not agreeing at that point. And, the cooler heads prevailing thing, I think a lot of times during mediation, it's really kind of getting your frustrations out there, making sure that you are being heard, feeling that you're being heard, and then having those expectations set for what is each person going to do to correct the situation. Oftentimes at that point, communication has broken down. So sometimes in an agreement, we even have, hey, we agree that within 48 hours, we'll respond to each other via text message. Now, the cool thing about this, and so I'll show this and then I'll stop sharing. The cool thing about this is this whole agreement started out this way. It was blank. And when you come to the mediation, everybody's coming with their own baggage and their own story and the results that they want to get to. And it starts out like this. And it ends up with all of these details and a solution to the problem. And I just think, having done a whole bunch of these so far, it's been really cool to see that process. And we've got one mediator in particular, Judge Brown, for those of you who are familiar with Judge Terry Brown, retired now. But he asks this question at the very beginning, and he just does it in such a nice way. And that's why I always remember him doing it. Most of our mediators do this too. But he asks the parties, especially after they've gotten some of their frustrations out, what is your goal of this mediation? And it really makes folks start to think about what is the reason that I'm here? What would I like to see? Because the other side might not have any idea what their tenant or what their landlord ever wanted. And just hearing it out loud and having third parties who are there who are not representing anybody, either affirm or say, hey, have you thought about this? Is just so beneficial in this situation, especially in a situation where folks have obviously come to such a hard disagreement that now we're in court. And so mediations, I think, absolutely pre-filing is just a great time to do it. We are working with a lot of landlords right now who have a ton of tenants and who would really like to get them, for example, rental assistance that folks are behind. And right now, especially right now, given all of the resources that are available in our state, this is an excellent time. If you haven't considered doing a mediated agreement, if you haven't considered that for tenants that you know or landlords that you know, everybody knows somebody. It is such an opportune time for folks to get caught up, for folks to avoid having an eviction on their record, for landlords to have stability in their housing, and for people to access the tremendous resources that are out there right now. And one of those folks that we've been talking a lot to about doing this pre-filing is Josh. And so it's great to have him on too. And, I think it's a really cool partnership to see how it works, especially for those folks who, are mom and pop landlords. I talk to folks like that all the time. Those who have property managers and can afford all that and lovely systems to track people and tell us where everybody is. But it is just such a great opportunity, especially right now, to really resolve these disputes, avoid all those costs that Karen was talking about, and to really have an opportunity to make these, especially during such a stressful time right now, to really find the best results for everybody. And heck, I mean, if it doesn't work pre-filing and then you go to court, just call us later. We'll try again, because oftentimes a judge, especially in the counties, might send you there anyway. So yeah, it's a really great opportunity. And Josh, I'd love for you to share your thoughts about this as well.
Well, so I'm uniquely situated in that I represent 6 to 7 nationwide low-income housing companies, and my clients are in about 30 some odd states, the US Virgin Islands. And so we're all grappling with this issue from a landlord's perspective. While you talk about mom and pop shops, multiply that by thousands of tenants. And we know just from sheer statistics that roughly, Karen said a half, but certainly a third of tenants to 40% of tenants are on the cusp of being evicted. And we also have rental assistance out there from a myriad of sources, federal government, state, local resources. And so my clients are looking at this saying, can we get some of our money back through these various rental assistance programs? And we've hit this, and by the way, I'm uniquely situated in the sense that Mike Geigerman and Robert convinced me to do the mediation program pre-COVID. So I started doing mediations where I reconnected to Karen. And so that's enjoyable because you get to see people you haven't seen since 30 years ago when I was in law school. So I've had the opportunity as a mediator to look at it from both sides. But looking at it from the landlord's perspective, you have a lot of money out there, and we don't really want to spend money on lawyers if we don't have to. And so we gauged this and said, so how can we engage our tenants to help cooperate with this process besides filing a landlord-tenant action against them? And I will tell you, until the last couple of months, it's been extremely difficult because tenants have seen the CDC guidance. HUD has answered questionnaires about how much notice you need to provide and what type of notice. It's been a changing field. And tenants have said, well, I can live, essentially think to themselves, well, I can live for free absolutely indefinitely, or at least they felt that way. But they've begun to recognize that this is coming to an end. Now, whether COVID is coming to an end, especially in Missouri, is a totally different story. But I think there is a recognition among our tenants that they cannot continue to live free indefinitely. And we have a lot of money that's owed to us. And so they're looking, my clients are looking at it saying, you know what, something is better than nothing. If I get 50 cents on the dollar for the last 18 months of rent, or 75 cents on the dollar, whatever the number is, maybe I'll be prepared to have these tenants stay. But at the same time, if I start spending money on legal fees, do I really want to cut them a break? So the most difficult thing of pre-filing mediation is, how do you get the tenant's attention, and how do you convince them that you want to work with them, as opposed to this is all a guise to get them out more quickly. And so we have teamed up to try to work on a small sample size of 50 of my clients, to try to send out pamphlets saying, here's an organization you can contact them, and then we're going to try to work together. So I think the most difficult thing for all of us is, how do we engage the tenants? But I'm telling you, Julie, from your client's perspective, there's a lot of money out there. And for your tenants with 9 or 10 who are risking foreclosure, and we are looking at a foreclosure crisis, if they could get 50, 60, 70 cents on the dollar without spending more legal fees. And I think we're at a unique opportunity where there is a recognition of the entire world that we're going to have, what is it, roughly, there are 110 million people who are renting in the United States. Let's just use a third of those who are potentially going to be out on the street. We're talking 30 million people, 40 million people. And you're also talking about a huge amount of funds that are available. And so this is the way to go for landlords, and it is the way to go for tenants. The one thing you all didn't mention, at least for those in any housing, is the judgment makes it very hard, Lee, for your clients ever to get housing again. For low-income housing, they can be out the black mark, so to speak. I don't, Lee, you'll tell me, it's either 3 or 5 years now that they can't get low-income housing. So we have things to offer the tenants, heightened security if there is a landlord-tenant action. It's just a unique opportunity, and I think we all have to figure out how to work together to get this done. So this is from a landlord's perspective, but also from a mediator's perspective.
I should have mentioned that Josh has done mediations and participated in arbitrations, but this is really wonderful to get different people's perspectives on this, because it is a very complicated, complex issue. There's no simple analysis of it. There's a new national report coming out of the White House, I think next week, that they looked at programs, mediation, eviction prevention programs across the country, that I'm intrigued to see what they came up with. A couple of points I would make. One is, Elad showed the MOU. And for those of you who are lawyers, particularly landlord lawyers, and Julie probably knows this from having done cases in the city, when it's in court, it's typically that results in a prospective consent decree. So the landlord has assurance. That's put in the file that if the tenant doesn't do what the tenant says they're going to do, the landlord can just walk in and get that consent decree. So that has been effective in the court cases. Josh it's wonderful to be able to partner with Josh and McCormick Barron, because it gives us a pocket of cases, maybe more than we're going to want. Because actually, Josh was saying that the complication was finding the tenants. Our initial complication back 6, 8, 10 months ago, when we first started doing pre-filing, was finding the landlords, finding a pocket of landlords that wanted to do pre-filing and would provide, access to whatever number, 10, 20, 30, 40, 50 people on the cusp of being evicted, that they would then send them a message and say, hey, we'd like to participate in a mediation. And you're raising a point that there's a certain dubious reaction on the part of some tenants, but we've had a pretty good response rate. On the technical end, we've been supplying iPads to different landlords so that the tenant can come to the office, get an iPad if they don't have access to it, go use it and bring it back. So there've been a lot of different complications. I have to kudos to Elad, who's really just knocked himself out at trying to figure out every possible way to approach this. I want to ask any and all of you to provide a few more words of wisdom. I wish this program was longer, but we've only got another 5 minutes or so. And you guys are some of the best people in town that know about these issues.
Well, I would say that I spent a lot of 2020 helping tenants after I'd filed and got them served. Once the court sort of woke back up, helping them get CARES Act funds. Because one of the things, to Mr. Schindler's point, like, had they made it possible for the landlord to do the onerous process of applying for these funds, it would have happened. But it was very difficult for the tenants, and especially the lower income or the elderly who didn't have access to the technology. And when those people would get in touch with me and realize that I would help them, I would email, I would scan documents, I would get what they needed. I would get the copy of the lease or a copy of the ledger. I said, I spent a lot of time helping tenants get that CARES Act money. And it wasn't until recently that they started opening it up and allowing the more sophisticated side of this transaction, the landlord, the person who has the attorney, to file for these funds, because that money is just sitting out there and it would prevent the potential foreclosure. It would also decrease the hostility between these two parties. You have a tenant who lost their job, who potentially was sick, who can't pay their rent and is terrified. And you have a landlord who isn't able to make repairs on the property and can't pay the mortgage. So, I mean, I would be an advocate for any way to get legislation pushed through to make that process make more sense for both parties.
And that was a huge move. When we had the tenants filling this out, it was next to impossible.
Yep.
It was the silliest start to this process. And I agree with you. We are the sophisticated ones. We are the people who can do it. And we're willing to do it because there is a tremendous upside for us. So Lee, this should be a positive to you. We are looking at this money saying, and now that it's 18 months, 20 months, this is, even though 50 cents on the dollar may not look, but that's 9 months worth of rent. And then you get a paying client. And let's not lose sight of the social consequences of what is going to happen if we have a huge homeless population out there. It's going to have an adverse impact, obviously, on crime, but values of those properties were already, especially my clients in low-income housing, but magnify that by a homeless population that could be on par with San Francisco's homeless population and the issues that come with that. So I think at this point, we've hit a beautiful, sometimes it's a perfect storm, which is a disaster. But in this case, we really do have a perfect storm. Landlords can get money. Tenants can either move on and not have a black mark against them. It is an absolute recognition that these tenants know they can't stay there forever, right? We've got a perfect moment where landlords and tenants should be working together, and pre-filing mediation, to me, is absolutely the way to go.
So we've got minutes. I want to hear from Lee and Elad, and I just put my email in the chat. So anybody, landlords or tenants or lawyers or people who want to volunteer. And I have to say, and I still want to hear from Lee and Elad, many thanks to all of the lawyers and now law students who are lawyers who have volunteered on a weekly basis for well over a decade to handle these kinds of cases. And really just kudos to everybody. What a great credit to the profession. Lee.
Yeah, I'll just piggyback on the rental assistance conversation. I think it's the most important conversation we could be having in any of these spaces right now. I have spent the last 6 months primarily working on that issue, advocating at every level of government to make this an easier process to get through, to allow tenants to apply when the landlord wouldn't participate, landlords to apply, vice versa. There is an option, for tenants that do want to move and that the blood is so bad they have to move, they can get prospective rent. Those efforts, CARES money was difficult when we were going through COVID in the heat of it in the summer. No one had ever been tasked with, a municipal government doling out millions of dollars to local residents immediately. That's not the case at this point in time. And it still has been slow. We are optimistic. The Treasury Department issued new guidance today. The White House has essentially activated the entire federal government across the board to find solutions to this problem. We're working on it day in and day out. I'm hopeful. I agree. This is the moment for everyone to work together and to combat this crisis. We will see how we do as a societal test, I guess, with that task.
I agree with everything. Absolutely agree. It's so important to do it. And I would stress, make it as easy as possible to do this, right? And so I mean, my phone is just blowing up. It's overheating all the time. I text people all the time. If it's a landlord who doesn't know how to text, a tenant who doesn't, we're calling, we're doing it online. But these resources are out there. We have got to get, that is the big big thing we have got to do as a state right now is get those resources to the people who need it, and that's the landlords and tenants in this situation. So if you do need any help, I will also put my contact info so you can
I'll
blow
just
up
put
my
it in
phone.
there.
Welcome. Yeah, great. It's already in. So wonderful. So blow it up. That's fine.
And Lee just put his in too. So really, thank you so much to all of you. It's really just heartening to think that maybe we've got some resources on different avenues that to deal with this situation, which just seems overwhelming and impossible. And Julie, thank you for adding yours for all landlords out there that want some advice.
I do actually have a tenant case right now in St. Louis County.
Call Elon if you want to deal with it before court. I will mention, Josh mentioned this issue of what happens to tenants is a negative for the tenants and a negative for landlords. That once the case is filed, because CaseNet is so effective. One of the downsides is that I can find if Julie's ever been sued for anything, anywhere, anytime for quite a long time going into the future. And if I'm a landlord, I might, even though it got dismissed, even though she paid it all up, even though I made a mistake, it's going to be on her record. So that's an unfortunate reality.
Karen,
Yes, sir.
it's certainly important to mention that we've changed the process from the old days where Julie would just cut a deal in the hallway and they'd have a consent judgment signed and filed, and that would be of record, as opposed to negotiating a continuance document with a consent that gets signed by the parties, not the judge, and then held, and then springs into a judgment if there is a default. And that certainly helps the tenants, but provides the safety net for the landlord. So it's just a process that I think we honed over the years. And folks, I thank everybody on this. You all are doing such important work, and it's going to only be highlighted in the future because right now it's landlord tenant. And I think, Josh, you hit it on the head. We're going to have a foreclosure crisis looming in the future.
But kudos to Josh as the final PS for McCormick Barron putting themselves out there and trying to actually create a new norm that will actually be more vivid than it's been the one-off pre-filings that we've been doing. But if there actually is more of a norm where major landlords say, okay, I want to try this approach before filing, that's a plus.
Karen,
Yes, sir.
Julie, Lee, Eli, Josh, thank you all. We really appreciate the conversation. It was marvelous, and we look forward to good things in the future.
Thank you, and USA&M.
Thank you
Our pleasure.
for having us.
Our pleasure. Folks, we're going to have just about 2 minutes, and then we're going to get started with our last segment, which is an ethics segment, and we'll be back in just 2 minutes.
Be here, just like probably most of you did, but I'm glad to be here again. And I recognize I'm the last program of the day, and I'm sure many of you are a little tired. So I will do my best to make this as interactive as possible, given our Zoom constraints. And I encourage all of you to put questions in the chat. I will be asking you a few things as well to kind of contemplate, but also you can add to the chat as well. So just briefly, as Robert said, I am the Deputy Director at the Illinois Supreme Court Commission on Professionalism. So I've been with the commission about 3.5 years, and prior to that, just so you have a little sense of my background, I practiced law primarily in the legal aid space. So I worked for 15 plus years at places like Legal Aid Chicago, Illinois Legal Aid Online. So the last coming on the housing portion, I definitely can relate and remember a lot of those issues. So I will get started, but again, please feel free to ask questions in the chat and be as interactive as we can. So we have just 2 objectives today. Try to make them as simple as possible, but yet as attorneys, we know there's always complexity, in some of the simplicity. So first, we're going to talk about why there are these high rates of mental health and substance abuse issues in the profession, and how they present ethical and professionalism issues. And then this is where we can get a little more interactive, is to really kind of talk about some strategies to strengthen one's resiliency, to kind of prevent us from getting to the point where we or our colleagues might be experiencing those severe issues. So some of you might remember this article. It's already almost 4 years ago, which is hard to believe. But this article, along with a few other things I'll talk about, really started the kind of lawyer well-being movement. And in this article, it was kind of really a alarming account of in the New York Times, about a Silicon Valley attorney who had been working for 20 plus years in the profession, working over 60 hours a week, pretty much every week, 60 hours plus. And the article gets into a lot of specifics, but really the bottom line is he was found one morning in his bathroom with drug paraphernalia, surrounded by drug paraphernalia. And even with all that going on, he was going in and out of consciousness that morning, and he dials into a conference call. And so it's just a very kind of chilling account of how this, over time, an issue not being addressed just continued to really build up. And so in 2016 is when this also got the lawyer well-being movement going. There were two impactful studies that were done, one for lawyers and one for law students. So the one for lawyers is what we're going to focus on a bit more today. And in that 2016 study, it was done by the ABA and the Betty Ford Hazelton Foundation. And they found that they surveyed over 13,000 attorneys across the US, and 1 in 5 lawyers describe themselves as problem drinkers. And this is actually self-identifying, so you can imagine it's probably a bit higher, as most people may not admit or not even know that there is an issue. In addition to that statistic, in that same study, 27% of those people said that issue began in law school for them. And then 44% said that the issue began within the first 15 years of their practice. And compared to other highly educated workforce, to think about it that way, whatever, dentists, doctors, et cetera, lawyers rank at a much higher rate for hazardous, harmful drinking. So you can say they're 21% versus 11% of the highly educated workforce. And then you kind of look at the data overall of the general population, and you see that that number is down to 6.4%. And the problematic drinking I defined there was in the study as kind of hazardous and leading towards a possible dependence. The 21% again is all the attorneys, and this stat is one that I think really is troubling for those who are focused on this issue in terms of trying to combat what is currently going on in the field. So 32% of those attorneys surveyed who said there was problematic drinking are attorneys under 30. So that's a bit alarming. And I think we can discuss a lot of reasons for that. Mostly from the research, it is found that if you look back currently at the current debt to income ratio for students, the debt is so high for students coming out of law school right now. The market has not been the greatest over the past several years. Obviously, the pandemic hasn't helped with that. So a lot of those are contributing factors that people believe is adding to this issue. So in this 2016 study on lawyers, in addition to substance use issues, they also focused on mental health issues. And so, here are the stats for mental health as far as attorneys go. So again, this is definitely some, some data that is pretty alarming, and one to kind of take a look at and not not really kind of pass over. To the fact that 11.5% of the attorneys surveyed had suicidal thoughts throughout their career is pretty telling that what is currently going on. That was a 2016 study. I wanted to present some newer studies because, as you can imagine, the pandemic has only increased the mental health issues. I'm sure you've seen a lot in newspapers, just overall the general population. And since the attorney population, already had an issue prior to the pandemic, the reports seem to be that that is continuing throughout the pandemic. So the issue is only sadly getting worse. So this was a study that just came out in 2021, and again, the numbers are up significantly from what I just showed, particularly on the anxiety realm of things. And obviously a lot of that goes to the isolation, change in just lifestyle. And so, this is, something that we definitely need to continue to keep our eye on. An additional study that just came out in May focused on, they actually did the survey of attorneys in California and the DC bar in 2020. So during the pandemic, this study was done. And during this study, they found that women actually are experiencing worse mental health issues and more hazardous drinking. That said, as you can see in this slide, men are not doing that much better in the legal profession. So these stats really come from 2020 during the pandemic. This definitely is, like I said, something to keep our eye out for and really be aware for ourselves and also the colleagues we work with. So you might be thinking, okay, so why is this an issue? Is there really much that can be done about it? There's several issues, and feel free if you want to type in the chat if there's some additional ones than the ones I've listed, but I'll briefly touch on these. Alcohol is really kind of ingrained in our culture as a profession. If you think back to probably when you were in law school, I know for myself, just the first social event in law school, there was definitely plenty of alcohol there. That continued throughout law school. It continues throughout, as you continue to practice. Obviously, the pandemic, there wasn't as many social events, so we didn't have that. But now getting back to quote unquote normal, some of that might start to again pick up. Lawyers are really not, there's a lot of stigma around getting help, and really we're the advocate, we're the one who are supposed to have it all together. So going to seek help, is a problem. That is not, people are not doing it. There's a worry of confidentiality. There's a big, a number, especially the number in Illinois is, 80% of attorneys work in solo or small firms. So this, is an isolating thing on its own, let alone the, pandemic. The numbers of people participating in bar association events is not, or even in the bar association is not as high as it used to be. And that was a place where people could talk, about various things, share frustrations, but those numbers are not as high anymore. And those social things obviously have not been around for a while. But if anyone has any other ones that they think of, feel free to throw that into the chat. And then, why we're here. I know the ethical rules and getting some professional responsibility credit, it really goes to, the basics of our model rules of professional conduct, the issue of substance use and mental health. In Illinois in 2019, the Attorney Discipline Commission reported that out of all their cases that came to them that year, 32% of those cases had something to do with mental health or substance use. Again, that's self-reported. So yeah, again, it's probably higher than 32%. And really, where those ethical issues come to a head is our basic 1.1 and 1.3, 1.4, which, competence, diligence, and communication. Obviously, with issues with mental health and substance use that, is not, no help is sought for, it really builds up similar to that New York Times story, and not getting any help really can, take a toll on you as an attorney and your ability to advocate for your client, and things get dropped, things fall off the radar, etc. And this is where problems really start to develop. In addition to kind of your basic rules, as kind of our beginning rules as rules of professional conduct, it's also important to think if you are, within a firm, you're managing other lawyers, you're charged by Rule 5.1A, that you are to make sure that all the lawyers that you are managing follow the rules of professional conduct. So if you do have an attorney that is, has an issue, and you kind of see it progressing, and kind of just let it go and don't really do much about it, there is the possibility that then can, you can be held with some responsibility for that. We did a recent conference at the commission, and we had a speaker by the name of Brian Cuban, Mark Cuban's brother, FYI. But for those of you who don't know him, he does a lot of work in the well-being movement in the legal profession. He has a book called The Addicted Lawyer. I really like something he says in terms of this notion of, kind of how do we talk with colleagues, about if we see something with, something is amiss, or we definitely see someone kind of really starting to drop the ball on a lot, and we notice a change in behavior. Right, we're not necessarily trained as social workers, therapists, etc. As attorneys. His goal and rule that he kind of practices is, if he does notice something with someone, he does what he calls the to ask rule. So the to ask rule is basically, you check in with the person who you see might be having an issue, just to say, hey, I just want to make sure everything's going okay. And most likely they're going to say, yep, all's well, no need to worry. You never know, but that's probably going to be the answer. So you put it out there once, and maybe a week or two, things still don't look very good. You put it out there again, another ask of, I just want to follow up. I noticed that it seems like you got a lot going on, and I just want you to know I'm around if you need anything. And Brian's point with this to ask rule that I like is that it puts the notion into that person's head that, all right, there are, maybe there is, people are starting to notice things, number one, but also there are resources out there. And so it kind of they might not come back to you necessarily, but it kind of gets that seed planted in their head that, okay, maybe there is something here, and maybe I should do something about it. So something to consider if you're definitely noticing things with colleagues as well. And so, the things also to think about is really if we continue to kind of let this build as a profession and, the mental health and substance use issues continue to, only increase, it impacts the profession as a whole. And, things, we just talked about the ethical violations, but it's also, the image of reputation of our profession, the clients losing faith and trust, the increased cost of insurance regulators, et cetera. So it does have a very profound impact that you might not, think about right away as far as what are possible outcomes. So, that's a lot of grim data and a lot to kind of digest there. But what I want to kind of focus now on is what are some practical things that, you can do for yourself, for others, as to ways to, really prevent getting to a point where there is an issue where you're going to have some sort of ethical violation, because there's that extreme, but there's also just the general, which, I think a lot of us have all experienced this past year of there's been a lot on everyone's plates, and it is definitely overwhelming not to, just alone the pandemic, societal tensions were at an all-time high this year, in addition to the fact that you have, most likely a full-time job as, in the legal profession. So we'll start here by kind of focusing on yourself and kind of just making sure that, give you some tools to think about what might be some ways that I can, make sure that my mental health is, on track. And if it's not, kind of working on some things to get it back there. So I will talk mostly about resiliency and building resiliency, because that really, is key here in terms of ways to really improve your own well-being, because with resiliency, it's all about how we handle stress. So in the legal profession, there's no way, it's always going to be stressful. I don't think we're going to be able to, it ebbs and flows, but we're not going to be able to knock that out, I think. So the stress will be there. What we do have some control over is, our reaction to that. And we all know that, right? It's been a long day, tensions are high in a case. The reaction to whether it be client, the other side, it can definitely be triggered pretty easily. So some ways to kind of think through how to best cope with the stress of the job. And so I always like to ask this question. This is an interesting data point. If people want to put in the chat, how many out of 10 lawyers rank in the 30th percentile of lower resiliency? So what number out of 10 of lawyers would you say rank in the 30th percentile or lower for resiliency? Let's see some answers here. 7, all right. Anyone else want to take a guess? Everyone's taking a guess. All right, I will. Very good. Meredith, you got it. I don't know if you've seen this presentation, but I use this stat before as well, but I think it's interesting because I think a lot of people think lawyers actually, it would be much lower than 9. 9 is obviously very high, and I think we do have that image that we have it all together, and And really the issue with, having a low resiliency is it's that, it means like we're, the defensiveness is on the high, don't take, criticism very well, not always the best bouncing back from setbacks, really kind of focusing on what went wrong. And really that then leads to a lot of decreased well-being. And so these are kind of some of the factors that show kind of a lower resiliency, and a lot of attorneys have many of these attributes. This comes, if people are interested, from it's the Lawyer Brain, it's called, the website. It's Dr. Larry David, it's his name. He's a litigator and also a psychologist. And so, just things like skepticism. I mean, we kind of are trained, and even if you weren't this way before law school, you kind of learn how to, even think about, right, what's the other side of the case? That doesn't sound right to me. This, you're trying to you really learn and hone those skills in law school, continue to hone them as you practice. There's always a high sense of urgency, particularly if you're in litigation. There's a lot of, you're really kind of autonomous, even if you're at a firm. You're doing a lot of individual work. And so a lot of this then really leads to a lower resiliency, which then impacts your overall well-being. The good news, though, good news here is that resiliency can be strengthened, and that's kind of what I want to focus on with you all today, as to what are some ways that we can build up resiliency. So one of the big ones is high quality connections, and obviously this is really, you can see this from the past year, right? We have not really had as much of that in the past year, where we really couldn't get together with people, get together with family for that matter. But when I'm talking about high quality connections here, it's not just, someone, who you're like, hey, how you doing? And it's always okay, or this or that. It's really some, people that you connect with that, really kind of add value to your life, and, really people that you're close to. And so, now that we are kind of moving away from everything's got to be on Zoom and getting together, it's really, important to kind of get back to, where have I lost some of those connections, and where can I, build them back up? And I think also the pandemic's really taught us that we don't always have to be in the same room as people. I think, that's really important, the in-person contact, but, obviously we all have people around the country, world, et cetera, that we can check in with, whether it be via Zoom or whatever tool that really, makes it possible to connect. So one thing I want to challenge you guys to just take a minute to do is, if you're, a kind of a calendar phone person, maybe you do it on your computer, maybe you do it on your phone, is to just take a minute to think about someone with whom you want to connect with. Maybe you've been kind of thinking about it, and you haven't really done it in a while, and take out your phone, computer, wherever you have your calendar, or if you have the good old write-in calendar, find a few minutes, whatever, anywhere from like 15 to 30, and create an appointment for yourself, who's someone that you want to connect with. And maybe it's just, you're going to send them an email or a text message, but go ahead and do that. Give you a minute to kind of just do that and think about that, and feel free to add anything into the chat as you do that. All right. Again, if anyone has anything to add to the chat as far as that goes, or what you're committing to, if you feel free to do that. But yeah, I definitely encourage you to, to follow through on that, and carve some time out to start kind of getting back in the practice of, whether you lost some of that, during the pandemic. So another thing that really builds, besides the high quality connections that build resiliency, is positive thinking. It's found, the research shows that positive thinking is linked to an increase in resiliency. So that notion of, what our mind focuses on kind of magnifies, right? So you kind of, you think about all that, you just lost emotion, hearing, and you kind of end up focusing on that and thinking about how it's going to impact the case, and it just kind of continues to spiral down, and instead of trying to kind of switch it to, all right, that was not the outcome we wanted, but what are some things we can now do to move forward, and kind of put the focus that way. And that's, in your practice, in your life as well, even thinking about the past year with the pandemic, I think a lot of us at times were, when is this going to end? Is it even over now, et cetera. But, also taking a minute to, hey, maybe I should, for myself, like maybe I should try to, instead of kind of thinking about that, maybe write down, each morning 2 or 3 things that, you're grateful for. It's a simple practice. It costs you nothing, but it does, the research shows that things like a gratitude practice really change our, thinking, and can really pull us out of, kind of going down that rabbit hole at times, of negative thinking. So I'm also going to challenge you on this one to give you a couple minutes to write down 2 or 3 things that, currently right now are things that you've just kind of been thinking about, mulling over, perhaps losing some sleep about. Write those 2 or 3 things down, and then categorize them as, what's in your control versus what's out of your control regarding those 2 things. So take a couple minutes to do that, and feel free to add in the chat, because we can kind of all learn from people. And thank you for people who are putting in the chat already. Yeah, I like that. One thing out of your control, definitely weather being one of those. Yep, for sure. Hopefully no one has any major events going on outside this weekend. All right, I'll give you just a minute to kind of wrap up your thoughts on that. Yes, some other good examples in the chat are in your control is self-care, how you are taking care of yourself. Out of your control, court delays. I mean, yes, we all love those things, right? Showing up and continuing to wait in court when you have 1,000 other things to do. Yeah, great one. Other people's feelings, not within your control. Thank you. Continue, feel free sharing. These are great. And I think it's important to sometimes just do, this might seem very, simple and basic, but it puts things in perspective because it really can, at times things, we can kind of lose sight of what how important everything really is or isn't. And so I will just say too, I actually do practice these as well before I present them. So I will just say the ones that I listed, it was interesting. Most of them, something like, for example, my mom's health, or kind of assisting with that as an example. A lot of the ones I listed, they actually would have a lot of subcategories to them, right? So, for example, say it's, a parent's health, yes, I have control over, the doctor's appointments and kind of arranging all of that. I don't have control over maybe my mom not doing her physical therapy, right? So, trying to break it down into what you can and can't really can kind of shift things and build your resiliency. So thank you very much for everyone for participating. Another big one that really kind of takes where resiliency takes a big hit is perfectionism. So this is really a tough one for lawyers because I think the general, if we generalize lawyers, they're probably tend to be more perfectionist than not, and so this really is creates a resiliency issue from the standpoint of I can just look at my to-do list from today, right, and about as a perfectionist, it's always longer than it should be, right, and so you can feeling like, well, if, I haven't gotten to all of it, then allowing that to kind of impact my day or how tomorrow's going to go, etc. I can give an example, work example. When I was at Illinois Legal Aid Online, we did a huge project where we were going from 5 websites to 1 website, and it took 2 years, which was plenty long enough. But if we had focused just on getting everything perfect, I'm sure it would have been at least 5+, right? So trying to get back to thinking about that, what's good enough, right? It's what is good enough that's not going to take a toll on my mental health and well-being. So another example kind of exercise, just to this one's a little bit longer, so this is something I'm going to invite you to do after the presentation when you have some time. 168, what's the significance of that number? And that number is the number of hours we all have in a week. And the great thing about this is no matter who you are, we all have the same number of hours, right? So that notion of you can work 110% or 120%, really is a myth. We don't have any more than 168. No one's got 175. We've all got 168. And the issue comes in with how are we going to spend that 168? And there is a book that is called Values to Action. It's called The 4 Principles of Values-Based Leadership, and it's by Henry Kramer. And he has an interesting exercise in there, and I'm going to encourage you. I know you guys have this PowerPoint. So these are kind of the categories he breaks one's life down into, everything from career to fun. And he encourages you to, first write down out of your, what would be your ideal goal for your 168 hours? Like, what would be the optimal? You're living your best life, as Oprah would say, right? With those 168 hours per week. What would that be? How would you put that? How would you divide that into those buckets? So maybe it's, career, I'm going to work to get to 40 or 50 hours a week, right? And then how else can I divide the rest of it? So to start there, first, what's your goal? And then second is what is your, looking at, say, the past week or the past 2 weeks, what's really the actual right now? Is it, that your career, you have, 60 in the work thing, your sleep's been way down. So looking then, taking, just being honest about what it's been, then taking your, what your kind of goal is versus the actual of all these things. And then thinking about how can I kind of get more to a balance? I probably am someone who doesn't believe that it's probably the work-life balance is, it's a tough one, right? Especially for this profession, and I think it's just something we're always trying to work towards. I don't, to perfect it is probably not a reality. So how can you better get to the balance that, you need, because ultimately you're going to be a better attorney if you can, really get to that. So I encourage you to try that exercise, use these buckets. Maybe they might not, you can even change the, the names of the buckets if these don't really resonate with you, but give it a try and see where you're at. And then, see where can you shift some things, where can you shift some of those hours, trying to be realistic about, your circumstances as well. And then, I've done this exercise several times, and it's nice, maybe if you guys say you do it this weekend, then come back to it, say in 6 months, and check in to see how it's going. Have you made some of those shifts? If not, where can you continue to shift? Because again, this is definitely just lifelong progress to keep it in place. But the more you're aware of it and thinking about it, the more you're going to most likely get closer to a more productive balance for you. And another kind of continuing along the resiliency theme, volunteering has, definitely shown that it helps to decrease depression, increase well-being. And so, for us in the profession, and obviously the housing issues that were just talked about prior to this, shows the huge need, for, pro bono. And it's probably only going to get larger as we continue to move past here, the pandemic and some of the funding being changed and all of that, and people's incomes, et cetera. So, so for this, it's, to think about, and I kind of broke it down into what's your passions. Maybe you're doing it already. Maybe, it's, tax law, for instance, and, or that's and tax is your, expertise as well. You're kind of doing both in that area. Well, where's some overlap there to, do pro bono work? Well, maybe there is, helping people during, tax season, getting the low income tax credit, various things are out there. Again, the housing, if that is something, you're interested in, there's a ton of programs out there. PILI, the Public Interest Law Initiative, is a statewide organization in Illinois. They have a lot of COVID opportunities that are related, like the housing piece, to childcare, et cetera. So there are the options out there. It's just, taking the time to think about what are, what would you enjoy doing? Maybe you are a tax attorney and the last thing you want to do is volunteer in tax. So, finding something that really, is more of your interest really can, add some, definitely enjoyment to what you're doing. So something else to consider in terms of building resiliency. And then the last one that I just mentioned in terms of building resiliency is finding that, outlet for you for stress. It's really going to be different for everyone, but, I think most people know what it is for them. It might be, you're a musician, and you're, now after the pandemic, getting back to, playing in a band, or, going to, art exhibits, etc. For me, I started doing yoga in law school and continue to do it, and that's a big one for me. One of the things I do is try to, at least, on the weekends, try to make a schedule for myself of, whether it's, yoga practice, exercise, make a commitment each day during the week to, what time can I give to it, Monday, what time can I give to it on Thursday? And I put it in, like a calendar. I do like a little calendar appointment, and, again, no, it's not going to be perfect. I definitely don't always, can't always stick to it. Don't always stick to it. But it definitely gives me a goal to have, and it is, again, picking something that you enjoy, right? If exercise isn't for you, that's not going to be your one to pick. But whatever it is for you, scheduling that into your week. So encourage you all to think about what are those kind of outlets for you, and adding them again into your calendar as well. So we talked about, a lot of ways to build resiliency, and some, resources that are out there, and ways you can, develop that and put that into your schedule. I also just want to point out, just excuse me, some other resources that are out there for you as well, to kind of contemplate and consider. So in 2016, I talked about the big study that came out regarding lawyer well-being. In addition to that, there was a national task force that then was created after that report came out, and it consisted of a lot of different entities. I list them out here, everything from the ABA to the National Conferences of Chief Justices, to look at this issue and say, all right, we got to do something about this. And so what they came up with, which was released in 2017, is this report on how can we get to a more well profession. And so in the report, you can easily access it online. It's free, and it's the path to lawyer well-being. The thing I like best about the report, it's lengthy. I don't think it's, I'm not recommending you got to read it all, but what they do that is very useful is they break down their recommendations for, changing the culture of well-being in the profession. They have 44 recommendations, but they break it down by stakeholders. So, they break it down for law firms, for law schools, judges, et cetera, bar associations. So if you are involved in one of those, or those apply to you, take a look at some of the suggestions that are out there, because they do give some good ones. For example, I just show you with an employer recommendation, for example, what are some things to think about? You can simply just start with, does my firm have some sort of policy for handling impairment? And if it doesn't, maybe I should think about adding that in. How do people go? Do people need to report somewhere? And how do I make that confidential if a staff is concerned about somebody? And if this seems daunting, I mean, we know that obviously some of the bigger firms out there have more human resources than smaller and mid-sized firms. If it seems daunting, I haven't mentioned them at all, which I'm remiss to do. The Lawyers Assistance Program, there's one in Illinois, one in Missouri. They're in every state throughout the country. They are a key resource, and obviously they provide not only groups, whether it be for mental health concerns, law students, substance use. They also can assist with some things like this. How can we develop something for our office that is a policy that people can know how to handle should an issue come up, and what are some educational well-being topics that my firm can add to the mix. So keeping all that in mind. Before I close, I want you to do one more thing, and then we can discuss any questions people might have. Now that we are kind of moving into kind of back to the quote unquote new normal, whatever that's going to look like, I think it's a good time to reset for all of us. So just take a minute or two to write down, type down, whatever is easiest, to think about two things. One, what's one thing you want to kind of add back to life now that you kind of weren't able to do in the pandemic? What's one of those things? And then the second thing is, what's one thing that you can let go of now that really wasn't, you realized during the pandemic, why was I doing that? That's really not necessary. I'll give you a brief one. For me, I definitely have an ability to overcommit to things. And I think trying to let go of some of that and realizing I don't have to, my schedule doesn't have to be booked up every minute of the day. There's a lot more to life. So take a minute to do that, and we can, if people have any questions. And as you're doing that too, I just want to share my contact information with you. Feel free. I'm happy to answer any questions via email I've got there. I'm on Twitter. The Commission on Professionalism has a great kind of social media presence as well. It's To Civility that you can follow on Twitter, or our newsletter and website contains a lot of information on not only well-being, but professionalism issues, diversity and inclusion. So there's a lot of great resources out there to take advantage of. I know I'm running close to time and you guys are stuck with me here. I'm happy to answer any questions, and I'm also happy to let you end the day early as well. I know it's been a long one.
Stephanie, that's great. If anyone has questions, if you would just put them in the chat and we'll be able to see them. We'll give that just a minute if we could. And Stephanie, would you be amenable to folks contacting you if they have follow-up questions?
Yes, yes, happy to. Yes.
Great. Great. Well, why don't we end this segment and end the group of programs? Stephanie, thank you for cleaning up the end of the day. This was actually really worthwhile to have all of us kind of stop and look in the mirror a little bit and think how we can really use self-care to move beyond some of the pressures that we have in our day-to-day world.
No, I'm happy. Thank you so much. I'm happy to be here again. I'm available for any questions, but thank you all.
And Stephanie, thanks again for doing this. Certainly, clearly a passion of yours, and we appreciate your expertise and taking the time to join us and give us some good materials as well. Folks, just a couple of administrative things in your materials. I think it's maybe the second or third page. There's an evaluation form. We would love to have your suggestions in terms of new topics and maybe proposed speakers. You can send that back in to Kelly K. Spiller at USAM.com. Like I said, our next program, September 17 in the morning, we'll do a half-day program. And we already have an ethics piece and a family law arbitration piece, which will be new. We thank all of you for attending throughout the day, and thank again all of our speakers. Just great material and outstanding presentations. So on behalf of USA&M and our partners over at the WashU Law School Negotiation and Dispute Resolution Program, thank you for attending. Thank you for contributing so that proceeds can go to Legal Services of Eastern Missouri, Land of Lincoln Legal Services, and the St. Louis Mediation Project. Thank you all. Be well.